I think we're all back.
Okay, well, I just have to find out if we're back up on YouTube so we can do the opening remarks for the afternoon.
Good afternoon, Chair. We are now live on YouTube.
Okay, thank you. Good afternoon. Due to COVID-19, Committee of Adjustment public hearings are being conducted virtually by electronic means through WebEx webinar, an online digital platform, and streamed on the Toronto City Planning YouTube channel. Participants who have registered in advance will be able to make their presentations to the committee using WebEx webinar, which is moderated by city staff. Anyone wishing to view the hearing may do so by watching on YouTube. Participants who have registered in advance will be connecting with their computer, tablet, smartphone, or telephone and have the option of participating via video or audio only. All participants will automatically be muted on entry, and when your item is called, each participant will be unmuted by the moderator, one person at a time. We also ask that you mute your devices until you're called on to speak. Those participating by video appearance will be temporarily upgraded to panelist when your item is being held. During this time, your camera will be enabled and you will only be visible during your 5-minute allotted speaking time. At all other times, your video will be disabled. You will be reinstated as an attendee. Committee of Adjustment staff will share presentations submitted in accordance with the written submission deadline. Members of the public and applicants are not allowed to use share screen or any other panelist controls during a video appearance, and the host will remove you from the panelist role if you fail to respect this instruction. Land acknowledgement. We acknowledge that the land we are meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat people, and is now home to many diverse First Nation, Inuit, and Métis peoples. And we also acknowledge that Toronto was covered by Treaty 13 with the Mississaugas of the Credit. In accordance with sections 45 and 53 of the Planning Act 1990 as amended, this meeting of the Committee of Adjustment of the City of Toronto was called to order. The Committee of Adjustment considers applications for variances from the provisions of the zoning that apply to the property, permissions to extend or alter lawful non-conforming uses, and consents to sever properties to create new lots. We have a couple of those this afternoon. Anyone in attendance today who wants to receive a copy of the decision of the committee on an application must submit a written request for a decision by email, and please ensure that you include your name, address, and email address, because the Committee of Adjustment and the Toronto Local Appeal Body will be sending notifications and appeal updates by email. If you do not agree with the decision of the committee, decisions may be appealed to the Toronto Local Appeal Body or in some limited circumstances to the Ontario Land Tribunal, and appeal instructions are set out at the bottom of the decision of the committee. The hearing procedure is as follows. We'll starting at item number 21, we go in order. We'll first deal, I believe there is one deferral matter that's been requested by community planning, and we'll deal with that first. In making your submissions, where an application is not contested, there's no one there in opposition, the agent or applicant may proceed with a presentation if desired. When the committee does not require a presentation, applicants are to advise the chair should they wish to address the committee, and the committee may ask questions and then take the matter into the committee for decision. Each speaker, including the applicant or agent, will be given a maximum of 5 minutes to address the committee, and there's a clock in the room, and you will be informed, hopefully, if when you have reached the 5-minute mark, and at that point asked to wrap up. When addressing committee, please start off by clearly stating your name and address, and remember to confine your remarks to the matters outlined in the application. The applicant or agent proceeds first and makes their presentation to the committee. And please note that the committee may not entertain revisions made to proposals made at the hearing today. The committee decided to defer the application if it's being substantially revised in order to ensure both that the revised application is accurate and that all those entitled to notice of the application have been informed of the changes. Then individuals either support or opposed to the application will be invited to speak. Committee members may ask questions of each speaker at the end of their presentation. And when all speakers are finished, the applicant or agent is given a further opportunity to answer those questions and rebut what's the issues raised by the speakers, not to provide additional information at that point. And that will then end the end of the discussion. The matter is then taken into committee for a decision. panel and staff, are there any declarations of interest to declare for the matters in this afternoon's time slot? Okay, none to declare. First of all, in terms of, is Mr. Comeric back with us? I don't see him on the screen. He said he was taking the remainder of the morning off, so just to clarify, is he
Here, Mike.
Sorry?
I'm here, Mike.
Oh, you're here. Okay, you were the only guy not on. Now they're on the screen.
Okay.
Okay, welcome back. Okay, so I believe we have one deferral request on the consolidated planning memo, which is item number 23. And it's for reasons 4 and 6. 6 being that no, sorry. Is that it? Yeah, 6 being where the agent is also requesting it. And it appears here the agent is David Eagleman on behalf of the owner. And it looks like he was the only speaker registered in any event. So, Mr. Eagleman?
Yes, good afternoon, Sir Chair and committee members.
Yes.
Through you, Mr. Chair, we are just requesting a deferral of this application because there was a missed variance on the public notice. So there is inadequate public notice. And this hearing has already been rescheduled for December 8th.
Okay, wonderful. Members, any questions for Mr. Eagleman?
Happy to make that motion for deferral.
Thank you, Ms. Alderson.
Seconds the motion.
Thank you, Mr. Bellissimo. All in favor? Okay, unanimous. You have your deferral. We'll see you here again, Mr. Eagleman, if not this afternoon when you're back on this application.
Thank you, Mr. Chair and committee.
Okay. Okay, so first item to deal with this afternoon then is item number 21. And that is 2709 Lakeshore Boulevard West. Looks like we have a couple of speakers where well, first I'll introduce it. This is an application to construct new balconies and interior alterations to the existing structure. And there are 3 variances. And we have the bookmark says supporting material. It's really just an email. We have 2 conditions from planning. And this matter, I note, is deferred from August 18, 2022. It doesn't say that on my bookmark page, but it appears to be. We can hear from David Mackay, the speaker on this. And it looks like we have a tenant in the building registered to speak, and a lawyer. It doesn't say who he's a lawyer for. So 3 speakers. Mr. Mackay.
Good evening or good afternoon, Mr. Chair, members of committee. Getting ahead of myself there. My name is David Mackay. I'm a registered professional planner representing the applicant. You were correct, Mr. Chair. The application was deferred at our request to deal with clarifications if any further variances were required. They were not through revisions to the plans. It was also requested a deferral to deal with the housing matters. As you will see in the staff report, staff have agreed that the housing applications can be conditioned on this application, and therefore we're in agreement with their request. The proposal is to retrofit the existing apartment building to add 4 new apartments, so a total of 10 apartments in the existing building. There are new balconies being added as well, and that necessitates parking variances. Parking is by way of a driveway at the rear of the building on the right-hand side of the picture you're looking at. There are 4 existing parking spots that can be accommodated on the lot, and we have accommodated 2 for residents and 2 for visitors. So we're deficient in the resident parking. As well, by necessity of the bylaw, an accessible space is required, and we're asking for a variance for that. Given that it's a walk-up condition, we feel that that's it would be beneficial to have it as a visitor spot rather than an accessible spot. Although I do note that visitor spot number 1 is wide enough to accommodate for an accessible spot should the committee be wanting that space. In terms of the supporting material, we have submitted a traffic study, parking study by X-Trans transportation engineers. They've identified that there are a number of parking spaces in the area in terms of paid parking spots for visitors and residents should they wish to have a parking spot in this area. Obviously, new tenants to the proposal would be advised that parking is limited and therefore would have to make arrangements if they have a car. We feel that the variances do meet the 4 tests of the Planning Act. There is a need in the city for additional housing, as everyone has heard in the news, and this will assist in a minor way for that additional housing. There's also calls for reductions in parking across the city, including council's approval of the new bylaw that eliminates parking requirements for all resident spaces other than visitors and accessible spaces. And that bylaw was approved by the Ontario Land Tribunal in October of this past year. Lastly, I note that transportation staff have not commented on the application. And as you're aware, if they do have concerns or comments, they do review and comment on the applications. So with those comments, I'll be happy to answer any questions that the committee may have, and we'll respond to any comments from the tenants and lawyer that I'm sure deal with tenant-related, landlord-related matters, which is not in the purview of the committee. Thank you.
Yes, sir, I agree that tenant and landlord matters are not within the purview of the committee, but anyway. Moving on, I just want to clarify when the matter was deferred, when I did the introduction, there was a lot of material before a committee back in sunny August when this matter was deferred that I didn't read into the record, but obviously that is before us. And we have the updated staff report. But all of that material is obviously part of the record, especially since there were no changes. The purpose of the deferral being to identify if any variances were missing, which they were not. So does anyone have any questions for Mr. McKay before we move on to?
Mr. Chair, I have one question.
Yep.
Pertaining to bicycle parking. Are you providing any, and is the landlord able to provide any?
Yes, so through you, Mr. Chair, there is a requirement for 8 bicycle parking spaces to be provided on site. We are not requesting a variance for those bicycle parking spaces, so we will be providing them, and they are shown on. No, they're not shown on the plans, but we will need to show those on the plans for the permit to clear that zoning condition. So we will be providing those as required by the bylaw.
I have a question of the applicant. Are you okay with the community planning conditions? There are 2 conditions, very specific conditions.
Yes, they're very specific, and yes, as I had mentioned at the last committee meeting in response to staff's deferral request, I had suggested that these matters could be conditioned as part of the committee decision, and staff have agreed with that position. And so I'm satisfied. We would have to do this in any event because we do trigger the housing requirements. Okay.
And is parking is not off of 2709 Lakeshore. It's not off of Lakeshore. It's off of Sandy Beach, or there's another street.
Yeah, it's off the back component. There's
it's off a different
laneway
street.
Driveway there that accesses the property.
Okay, thank you.
Okay, any other further questions for Ms. McKay? Okay, if not, the next speaker is Robert Zalozzi. Just says he's a lawyer, doesn't say who he's acting for. So we'll find out. Welcome.
It's Zalozzi, and I represent the tenants at 2709 Lakeshore. And I represent them mostly in front of the landlord-tenant board, but as part of that whole process, I've also been representing them here. Not all my clients are able to attend today. They have to work, so I believe one is here at least, Karen Horwood, and I'm speaking on their behalf.
Okay.
Should I start?
Yes, go ahead.
Okay, so the first thing I just wanted to note that there was a letter sent from the new Councillor Morley, and I don't see it in the documents. It was sent November 18th, as I'm sure the committee is aware. Ms. Morley only took her office on the 15th. So it was provided to us and sent on the 18th of November. It essentially echoes what the previous councillor had sent in August, and I'm happy to provide it. I do have a copy if you don't. So
I don't personally have one. Staff, did we have that in the file? Wasn't in our additional materials or regular materials? We have the old one from Councillor Grimes as he then was back in August.
right.
We don't have that,
Um,
no.
I don't see anything.
Sorry?
I don't see anything from Councillor Morley.
Okay, when I'm done speaking, maybe I could forward it if that's acceptable.
Okay, we'll take your word. It's similar as what Councillor Grimes was saying. They were in favor, I believe.
They opposed.
But
Yeah,
at that point, yeah, the difference, like to see the letter, because it says at that point, Mr. Grimes, as he often did, he'd say, I agree with the guidance of city planning. Should the committee decide not to defer, it should be refused. The omission is very important, needs to be addressed. So anyway, there was the talk about the rental housing demolition application. So it would be nice if we do, if there is a letter from Councillor Morley to see that. I believe she did weigh in on one of our other applications that's coming up this afternoon, but I didn't see a letter, anything from her on this one.
Okay, as I said, I can forward it.
Okay.
I just want to wait or take more of my time to sit here forwarding it.
Yeah, okay.
Okay. So with regards to the planning report, the first thing I want to note is there's a couple inaccuracies in the planning report. It states that the 2 basement units are vacant. That's not true. One of the basement units is tenanted with long-term tenants. They've been there several years. I sometimes lose track about which tenants have been there how many years, but it's been several years that they've been there. And the other unit was vacant until the new owner provided N13 notices for demolition, which were then withdrawn because
Did we just lose the speaker or everybody?
Robert, we're not able to hear you. He is unmuted, so not sure what happened.
Robert, we're no longer able to hear you.
I believe he has lost connection because I have no capability of muting him or unmuting him. So Robert, if you can hear this, maybe log out and log back in. Mr. Chair, he did just drop off of the call, so would you like to hang tight and wait for him to log back on the call?
A question for staff should be perhaps stand that down here from the next speaker, which is a tenant. I'm not sure what, perhaps you want a lawyer to speak for, or we just have to stand it down, I guess, or just stand down the whole application and go on with the next application.
Well, we can hear from the next person and then maybe he'll be able to rejoin.
Okay, so the next speaker is Karen Horwood, tenants in the building. Welcome, Karen.
Thank you very much. I was hoping that Robert was going to be able to speak more so on my behalf. Hopefully we will be able to have him reconnected shortly. I just have a few things, as Robert was mentioning about the demolition permit. I don't believe that this hearing should be proceeding as scheduled today, as the landowner had this matter deferred until this time to apply for such things, and yet he has not applied for this. I've been in this building since 2007. It is my home, my neighborhood, and I don't believe that that turning our affordable two-bedroom units that in a place that we love and our community, as I said, he is not contributing to the community in affordable units, permanent residents, because his mandate is actually to cater to the Humber College students that will be mostly international students, because that he's done in other buildings in the neighborhood. And it would be a shame to see this one suffer the same fate. Secondly, there was a recommendation in the files that you have there by the TRCA, the Conservation Authority, because we are mere meters from Lake Ontario, and he, as far as I know, has not applied for the TRCA permit either for any of the outside work. He does have a photocopy, nonetheless, of a building permit posted on the front of our building. It's been there since January, and there's been exorbitant, upwards of 106 decibel noises in our units while he's already been doing construction inside. And I'm not sure if I misunderstand, but the TRCA's letter says that no municipal permits may be granted until they've gone through with that TRCA permit. So that's my two big important things. And I would obviously hate to see my home be lost to international temporary residents of our community.
Okay, thank you, Ms. Horwood, for your comments. Mr. Mackay will respond in due course when he responds to, we get Mr. Zolzy back.
Mr. Chair, he is
Thank you
back
very
on the
much.
line. Robert is back on the line.
Oh, excellent. So, and in the meantime, does anyone have any questions for Ms. Horwood before we go back to the lawyer for the building? No one has questions for Ms. Horwood? Okay, so welcome back, sir. And I guess you were sort of retained by like a tenants group in terms of, introducing yourself. You were retained individually by certain people.
Yeah.
And then I guess you can really restart your presentation at that point.
Sorry, you cut out there right as you were saying where you last heard me. And it was weird because as you were talking, you were all talking about how I was no longer connected, and I could hear you talking about it, and I had no way of unmuting myself.
Yeah. Well, these things happen.
So sorry,
To me
I'm not
this
sure
morning
what
on
you
the city
last.
computer. Okay, so do you want to, you can proceed. You want to start over if, that's fine. So.
Okay, so I addressed the issue with the letter from Councillor Morley.
Right, were you able to send that to us, or while you were reconnecting, or we haven't seen that? Or perhaps you just want to read it out if you have a copy in front of it. I'm sure is it one paragraph or something? Did we lose him again?
I think we did. Robert, can you hear us? I think we lost him.
The joys of technology.
Yeah, well, this morning on the city, I don't know if you could hear that. It sounded like, Amber Alert on my city computer I was using as a camera. And it happened the second time and just it wouldn't even turn off. For after 5 minutes. So anyway, perhaps do you want to stand down if it's going to, hopefully he'll get back quickly. Or we can move on to the next, the next application. You know, I know it's good to have continuity and get this important application, not to lose our train of thought. But Barb, any insight from staff?
Yes, I think we should hold it down. Maybe he can call in so that we can have a continuous conversation, because there's obviously an issue with his connection. So why don't we
not
move
appearing by video anyway, so.
Yeah, so why don't we move on to 22, and then when he lets us know that he's called in, then we'll come back to this item.
Okay, thank you. Item number 22, where we have a revised notice on this highlighted to show the changes proceeding by waiver. It's to construct a new detached dwelling with an attached garage. There were 6 variances, there are now 5, and one of those has been revised. Then we have a cover letter with supporting material, presidential precedents and renderings, arborist report, forestry, looking for conditions 2 and 5, and I believe we have a memo on that. And we have support from both adjacent at 25 and 29 Inverly Drive. The speaker for this application is Dejana Pejovic.
Good afternoon, Mr. Chairman and the members of the committee. My name is Tatiana Pejovic, and I am the agent for the owners of the property at 27 Inverly Drive. After submitting the application, we received the comments from the planner, and they expressed concern about the originally proposed floor space index of 0.57. In order to comply with the planner's request, we produced a revised set of drawings in which the length, the coverage, gross floor area, and the resulting floor space index were decreased. By reducing the footprint of the house, the initially proposed coverage of 33.7% is reduced to 32.06%, which is below maximum permitted 33%, and in that way coverage was removed from the list of variances. In the revised design is at the same time decreased gross floor area, and the new floor space index is lowered to 0.537. After a review of a revised design, we received the email that the planning staff have no further objections to this proposal. I would like to give additional explanation regarding the other variances listed in the zoning waiver. The proposed side setback from the north and south side property line is 0.91, while minimum permitted is 1.2 meters. I would mention that the proposed north side setback is along the side garage wall, while along the remaining length of the north side wall setback is 2.44 meters. The variance regarding the eavesdrops, where proposed distance from the side property line is 0.22, while minimum permitted is 0.3 meters, is resulting from the proposed side setback and the proposed moderate size of a soffit, which is 56 centimeters. According to Etobicoke zoning bylaw, maximum permitted soffit height is 6.5 meters, while in the design is proposed 6.99. According to citywide zoning bylaw, at the same time, the maximum height of the main wall is 7 meters, while in the design is proposed 1 centimeter lower than permitted, and the soffits are also at the same height. The proposed width of the garage is 5.59 meters, and it is slightly smaller than required 5.8, required for 2-car garage parking space. We tried to provide more information and explanation for some of the variances in the supporting document, which was uploaded on the website. The owners of the property, 27 Inverly Drive, had also communication with the neighbors, and they received 2 letters of support from the south side neighbor and from the north side neighbor. We are aware of the forestry report dated November 16th and the concern regarding the variance related to a garage width. And as it is further explained in the section additional information of the report, actually a concern about the construction of the driveway leading to the garage. We would note that the proposed garage is around 4 meters away in the closest point from the tree protection zone of the city-owned tree, as it is shown in the submitted tree protection plan. We hope that the optimal width of the driveway, which will satisfy requirements expressed in urban forestry report, and at the same time allow access to the garage, can be explored and determined during the stage of application to injure a city-owned tree. In the submitted arborist report is noted the recommended approach of route exploration for the city-owned tree, after which can be determined the impact to the tree. The issue with the driveway we believe, can be explored in details after obtaining additional arborist report following exploration phase. I would mention that the other features of the house, like the height of the building, its length, and the coverage, are below the maximum permitted by zoning bylaw, and we believe that the house form accordingly is average in mass and volume. We hope that the proposed variances can be considered as a minor and that we can have your approval. And I would be happy to answer to any questions. Thank you.
Okay, thank you for that presentation, Ms. Pejovic. Panel members, anyone have any questions?
Just a question of clarification from Danny Bellissimo. Forestry in their summary sheet here says F2, which is a permit for private tree removal. So there's a private tree being removed as well? Is that?
There is proposal to remove 2 private trees, and
Okay,
the owner already submitted the application.
So, and you're okay with that condition, right?
Yes, we are okay.
If there are no further questions, I can go ahead with a motion, but I'll wait and see.
Okay, so just to summarize what you're saying, I think you were saying that your clients are going to try to, at the relevant time, work to try to save that tree by dealing with the driveway, however that's been done, and after you've had some preliminary results of some investigation.
Yes, the owner, of course, is willing to revise the size of a driveway to work with the forestry department and to find, in fact, the optimal width of the driveway, which will be responding to requirements from the urban forestry, and at the same time will allow to have access to this width of the garage. Because, of course, generally it's not necessary to have, and we were already thinking about this, that the necessary curb allowing access to a garage will still have possibility to be made in front, in the area where is the porch part, but the entrance to a lot can be decreased according to the details that will be found following a route exploration of the tree.
Okay. Yeah. Okay, because I have it up on the screen here. Tree number 1, beautiful tree. Okay. Any other questions, or Danny is prepared to make a motion?
Yes, I can make a motion. I feel quite satisfied. That's an old tree and it's going to survive in my mind. So I'd like to move approval of the variances as revised, and that'll be variance 2, 3, 4, 5, and 6. Conditional forestry F2. Do this one a condition.
Okay, thank you. Seconder for that motion, Mr.
Chair,
Kapara.
seconder with a slight amendment. I believe forestry is also asking for an F1 to try to save that tree. So I'd like to add that. It wasn't in the consolidated report.
I saw that in the other report, but I can add that. There's no problem with that. The applicant obviously is going to work closely with forestry, so I feel confident. Thank you. We can add F1 as well.
Good catch. Yeah, clearly that's before everyone on this committee, the public tree, not just the private ones. Okay, all in favor? It's unanimous. Thank you, Ms. Pejovic. You have your approval. Be well. Any luck in getting back Mr. Zalozzi? Or we'll go on to item 24.
I don't think he's back yet, so maybe we'll keep going and we'll let you know once he's back.
He
Okay,
is back on the call.
Oh, okay, sorry.
Okay. Welcome back, sir.
Am I been unmuted now?
Yes.
Okay, here we go. It's got me on both. I'm on the phone as well.
Yeah, that's where we're getting an echo, but maybe stay on the phone so we won't cut out again.
Okay, and we can just
Give up.
mute the.
Yeah. Because you'll have a hat trick if we lose you one more time. Hello? Who's here? Okay, I have visual on the members.
Robert, you are unmuted once again.
Okay, I'm unmuted.
Yes.
Okay. So I do apologize for. Okay, sorry. I'm getting an echo. Are you getting an echo?
Not anymore.
Okay.
First word you said it was, and then it went away.
Okay.
Are you getting an echo? Because that was obviously very.
Well, I muted myself on my computer, but I'm on my phone.
Robert, I can expel your computer and you can talk off
Just-
of your
yeah,
phone instead.
Yeah.
Okay, that would be great. Thank you.
You're not on video anyway, right? So what's the difference? We'll have better luck with that maybe, but I think you have to turn it off, mute it. Yeah.
There we go. I think we're good now. Are we good?
Yeah.
Okay.
Here
So,
too.
oh, I was removed from the meeting. Okay. I believe that I spoke to the planning report and the inaccuracies in there, and I believe I was in the middle of talking about the rental housing demolition application. Is that where we got cut off?
Yeah.
Okay. So, I think it's been said, and we, I acknowledge that the rental housing, it can be conditioned, this process can be conditioned on that. But again, I'll just say, the first writing in notice from city planning was January 26th. And I can't think of any reason why that application process hasn't been started in those 10 months for the rental housing demolition application, which would be required or conditioned. I heard briefly when I was coming in and out, my client Karen spoke to the TRCA application, and my understanding to this date is that is another required component that has not been obtained. I did read the report that was included, and it seems like it could be obtained if the process was done, but it's another thing that hasn't been done. So, there's another aspect of it that is just not being followed through with. And just before, I don't want to take up too much time, I realize this is not the place to discuss landlord-tenant matters. What I will say to that is my clients, I had alluded to earlier, received notices of eviction for demolition when the landlord owner realized that was not, that wouldn't be upheld because of not having the correct permits and the correct approval. They were then reissued.
Did they get rescinded? Didn't we hear something about
those were rescinded, and then new ones were issued for renovation, which allows the tenants to move back in. The initial ones that were rescinded, one of the tenants moved out. The second ones still haven't been heard at the landlord-tenant board. There was a date scheduled, but due to administrative matters, it wasn't heard. So there should be one coming up soon. One of my clients left willingly at the end of May with the intent to return and wasn't able to return because of insufficient notice, and also because it was listed on Airbnb prior to that time being up. So what we're facing here is, just to kind of summarize, is there's a lot of process going on to try to get my clients out. I heard the agent for the owner speaking to the need for housing. It's true to an extent. There's a need for affordable housing, and this has the exact opposite of that. It's being rented out on Airbnb for significantly more than my clients are paying. A lot of them are long-standing tenants, long-standing members of the community. I believe Karen and Rob Horwood, Karen can correct me if I'm wrong, but I believe they've been there 13 or 14 years, maybe even more. And several of them have been there over 5 years. So, as far as affordable housing goes, this runs counter to that. And I encourage you to look at the letters of objection from the previous one in August and from the current, which I've sent to Olivia. I don't know if she's received it yet, but I sent the letter from Councillor Morley as well.
Thank you, sir. I have a question. I have a question just to raise with Mr. McCoy to answer. It looked like when his original August 17th letter asking for a deferral, and the reason for it, he wanted a hearing, get back on September 15th or as soon as possible thereafter. So the question is why it took another 2 months. Whether he's, but a question for, as you know, we're not only just dealing with planning issues here, we're also not a punitive body, and any actions by the owner unrelated to that, really should not be considered. But they, like I said, I think I take certainly comfort that people have rights under the Landlord and Tenant Act in these circumstances, and right to return and things, and compensation if they want to move out. That is not really before us. We deal with the planning and built form issues. So I'll ask that of Mr. McKay when it's his turn. I assume does anyone have any questions for Mr. Lozzi or
Andy Bellissimo has a question.
okay.
Bit concerned that we haven't seen Councillor Morley's letter. Can you just give me 1 or 2 sentences of reason for refusal that she's provided?
It's a very short letter. I can read it to you if you like. It's not long.
Just read me the highlight.
Yeah.
Okay. I have reviewed the application and in line with the guidance of City Planning. Should the Committee of Adjustment decide not to defer the application, City Planning staff recommend the minor variance application be refused. So I think she's referring to the older one. Furthermore, to date, a rental housing demolition application has not been submitted or received. This submission is important and critical to ensuring tenants' rights are upheld with respect to their right to return to the unit at similar equivalent rent. And I do not support this application. That's the entire letter.
Thank you.
Okay, so she's referring to community planning previous, not realizing that they are now agreeable to certain conditions that they're asking for. Okay, so anyway, let's go back to any other questions for Mr. Solozzi, or let's go back to David McKay to rebut and to answer why it took 3 more months.
So, thank you, Mr. Chair.
Yeah.
So with regards to the timing issue, that frankly, that's just how the committee operates. We did resubmit the plans after we received the zoning notice, and that was in October. So the process to get the new zoning review, and this is the date that's available. So that's in terms of the timing issue. Relative to the comments that have been raised, again, none of them relate to the variances being requested. As I had mentioned to the committee previously, when this matter was being discussed about deferral and whatnot, is my client, if the variances aren't approved, then my client doesn't have a project. So why would he go through a whole process to deal with rental housing, TRCA dealing with exterior matters, not interior alterations, et cetera, if the variances aren't approved? So that is why we are here today, and that is why we have not applied for those applications. It's putting the cart before the horse relative to the planning process. And so with that, those I believe are the questions or the comments that were raised. With regards to Councillor Morley's letter, obviously she hasn't been briefed by planning staff on the updated report that they've written, which is supportive of the application subject to conditions. And so I would give that very little weight to the committee. Be happy to answer any further questions.
Yeah, so basically, before I get to Mr. Kumar, it's a matter of expediency. You're not going to spend money on a project that doesn't get approved. So you go from step to step to step. There's nothing sinister at play there. That was just the way things work. Okay, Mr. Kumar, you had your hand up first.
I just want to pursue that step-to-step process. I know one of the tenants mentioned that there's a building permit that's been pulled. So just out of curiosity, during the downtime, I visited the building site, the permit site, and I noticed the applicant has pulled an HVAC permit. And the stated purpose of the HVAC permit is for closing exterior windows and new balconies. So again, I'm not sure about the consistency of that. Why would that be applied for in January if you don't have your variances yet?
So through you, Mr. Chair, I'm not part of the that permit process. However, again, my client was trying to move matters forward. Part of that is building permit review, part of it is zoning review. Need to understand what it was required. I understand that he did, as you said, mentioned, was able to get a HVAC permit issued for portions of the work. So, and the rest of it is on hold at this point until the variance comes forward. So I don't have a further answer.
No, I'm just pointing out an inconsistency in your previous statement. That's really all.
I'm dealing with the planning process, or not the building permit process. So obviously he applied for the permit, got flagged that he needs variances, and that's why we're here.
It may even be more simple than that. Not that I'm trying to help anyone. It's a good catch, Stan, of good sleuthing. Maybe it's certain as of right renovations that aren't affected by this for the HVAC system. That we often see that. We ask tenants, "Hey, why do you have a building permit?" They say, "Well, there's certain things I'm doing as of right, and I'm just proceeding with that to save time." So just a possibility of that, because it's for HVAC. Okay, any other questions, or is someone ready for a motion?
I had my hand up before, Stanley Badisimo.
Go ahead.
Bit confused. You need to help me out here. Like, you were here before, and I looked at the revised plans of the interior, and basically what I see has changed is that there was a linear corridor, and now that's changed. So you have revised floor plans compared to the first time you were here. And my question then relates to how many existing units are there in that building?
So there are 6 existing apartments.
And the proposal is how many?
A total of 10.
Okay, so you're going from 6 to 10. Okay, thank you.
And the changes to the plans were relative to the exiting requirements of the OBC that were required, and that's why we wanted to make sure that, you know, that plus the exterior additions didn't create any further variances. That's why we deferred it.
I was confused. So I couldn't find drawings of the existing condition. I just saw proposals. So you're going from 6 units to 10 units. So, and that's triggering, then you're doing balconies as a result, and that's triggering these variances.
Correct.
As well. Okay, that just wasn't presented clearly. Now I understand. Thank you.
Apologize. Yeah.
Okay, any other questions? And if not, is someone ready to weigh in with a motion?
Sure.
Oh, thank you.
Okay.
Go ahead.
Yeah, I think if we reel back an hour or so and go back to our mandate, this is really, I think, a pretty straightforward application for 3 relatively straightforward variances. I'm satisfied that the 4 tests are met. I'm satisfied that the process explanation makes sense. I'm satisfied that the community planning department has put in conditions regarding the rental housing demolition permit, and I move approval subject to the community planning department requested conditions of approval.
Thank you, Mr. Taylor. I have a seconder for Mr. Taylor's motion. Mr. Komorik. Thank you. All in favor? Opposed? Motion carries 4-1 with Ms. Alderson dissenting.
Thanks.
Thank you. Thank you, Mr. McKay. Thank you, Mr. Zalozzi and Ms. Horwood, for your participation, and have a great rest of the day. Okay, that's we're over at item 24. It's 91 WESTROSE Avenue. We have a revised agenda page dated November 10th. And this is to construct a new detached dwelling. We had 5 variances, now 3, one of which has been revised, the FSI from 0.63 to 0.58. We have revised zoning and revised plans, supporting material, and arborist report, and the application revision email from the applicant. Planning has a condition of approval. In the event of approval, they would like it constructed as illustrated with respect tying it to the length. The in the plans, the architectural site plan. And we have forestry looking for conditions 1, 2, and 5 being a refusal, item number 5, and a standalone memo, and as well a Metrolinx advisory. In the additional materials, we have a letter of concern from 168 Brentwood Road North regarding trees and overlook. And the speaker on this application is Franco Romano, as well as we have the neighbor who wrote in registered to speak as well.
We do not have the neighbor on the line.
Okay. Okay, so we have Mr. Romano. So the neighbor, did they ever register, or they
Yep,
weren't on
they
the line today?
registered, but they did not log on to the call today.
Okay, thank you. Okay, Mr. Romano.
Yes, good afternoon, Mr. Chairman. Franco Romano here on behalf of the owner.
Welcome, sir.
Thank you.
Want to make a short presentation for us?
Yes, thank you. So thank you, staff, for bringing up that revision page. So I'm seeking revision to variance number 1, which is a floor space index, changing that from 0.63 to 0.58. And you'll see the 282.45 square meters. Variances 2 and 3 are being deleted. That is the front yard and the rear yard setback. Variance 4 and 5 are being retained. So those are building length, 18.88 meters, and driveway width of 5.63 meters. Now, if staff could kindly bring up my presentation slide, because this property is unique. If we go to the supporting the applicant's presentation page, please. Excellent, thank you. And maybe if in red, I have outlined the triangular shaped lot. And if we can somehow blow up the site plan a little bit, you'll see that the center of the lot runs from the middle of the lot line along Westrose Avenue to that lower right-hand point, which is the rear lot line.
Yeah.
So the rear yard setback is from that lower right-hand point where the hypotenuse, so that angled side lot line, and that south side lot line, which is at right angles to the front lot line, meet. That is where the rear yard setback is. So that is now zoning bylaw compliant. So that angled side lot line is a side lot line, and the south lot line is a side lot line. The way building length is being measured by the zone examiner is that broken black line that runs from the middle of the lot at the front lot line to that pinch point rear. I'm hesitating to even call it a lot line, but it is the rear lot line.
Oh.
So that is how building length is measured. The conventional building length, how you would see it, is from front wall to rear wall, and you'll see that the northern part of that house is 5.79 meters in length, and the southern part of the house is 11.46 meters in length. The yellow that I show on that site plan is the existing house. So you'll see that the angled condition along the east walls is in a staggered form to follow that angled lot line. And that is where the basically an expansion of the existing footprint is being proposed, albeit it's new construction. So that's how building length is being measured. I also have some orange lines there that if anybody has any questions, I can point to in terms of building length. But that is why staff is looking for that condition, which fully supported of to tie the any approval to the site plan as it relates to length. The parking, the driveway width variance is also technical in nature, and I have noted that as a 5.63 meters, which you'll see along the driveway that's attached to the, I guess, the northern part of the front front wall of the dwelling. So neither the floor space index, building length, or driveway width variance have anything whatsoever to do with any city tree. So urban forestry's recommendations for refusal based on the refusal of variances 1 and 5 is misaligned with what the actual proposal is seeking. None of those variances deal with any city tree. So the floor space index is in keeping with what's found on the street, WESTROSE, and on surrounding lots that are even more conventionally oriented. And it's a modest size. So if we can scroll to the top of this slide, you'll see the front and the rear elevation. It's a conventional 2 stories, building height, wall height, all compliant. The rear elevation that I'm showing there, that is the rear wall that faces the side lot line. So this rear elevation is staggered. And you'll see that there are no windows that would interfere with the resident that had written in regarding privacy or overlook.
Okay.
I think also mentioned that on the site plan drawing, there is no impact of the building footprint on the tree that neighbor has written in as well. So subject to any questions, sir, I submit that the revised application with the 3 variances satisfy all 4 tests for a minor variance and creates no unacceptable adverse impact.
Thank you, Mr. Romano, for a good presentation. I think to mention very pragmatically, everything here is technical. The fact someone's been able to design a house that hasn't that's been able to pass the scrutiny of neighbors and community planning on such a wonky lot. And I would say that any of those measurements other than FSI and FSI coverage and height are all just technical anyway. And the real test is to look at it and see, does this fit on this lot? This very strange, wonky lot. And the rest is just technicalities. So that's just my comment on that. And I guess I was going to say, let's speak for the neighbors who are on the line who did write in a letter. So you did touch on that. I just say as a devil, speaking on their behalf, because when we say an application is opposed or not, it's not just if someone shows up here to speak. You got to look at the letters too. So if you'd like to expound on their, satisfying, there seems to be the only neighbor who raised anything, and there's a lot of neighbors affected, but I would just wanted to mention that they're not here, but you did deal with it. That
I did. Yeah, thank you for that, sir. So as I mentioned, the tree that Norway maple tree that is on the neighbor's property is not being affected by the proposed building footprint. The footprint actually has a larger side yard setback than the zoning bylaw requires in relation to that tree. I know the letter talks about the rear yard setback, but there is no longer a rear yard setback variance, and the rear yard setback does not affect that tree anyway. It's actually the side yard setback. And the privacy or overlook that was mentioned is not being impacted as well, because I showed the rear elevation, and the portion of the building that's nearest to that neighbor actually has no windows. Okay. That's that staggered part of the rear wall of the house.
Okay, so did anyone else have any questions for Mr. Romano based on either the neighbor's concern and or the application generally? And if not,
question, if I may, Mr. Chair. Mr. Romano, it's a U-shaped driveway that's being proposed?
Yes, sir.
And is it the nature of the U-shaped driveway that's affecting one of the trees? Because currently it's just a straight driveway, is it not?
Currently it's a straight driveway, it leads right to the house. The proposal accommodates a circular drive. It's permitted by the bylaw, and there's no variance related to.
It's permitted because of the width of the lot. I understand that. Yeah. Wonky as it is, it does give them that benefit. But is the entire driveway going to be that wider variance, or is it just a portion of the driveway?
No, I mentioned if my supporting material can be brought back up and it can be blown up to highlight the house, please, staff. Thank you, kindly appreciate it. So if we look to on the left-hand side, you'll see WESTROSE Avenue.
Yep.
running up and down. And if we follow the W to the right, there's a driveway there. The driveway is actually 3 meters wide in the boulevard.
Okay, and the other entry point
The
is also,
5.63 meters is basically the throat of the driveway.
and the other entry point, the one to the south is,
One to the south is 3.8 meters.
okay, so it's only that portion that's parallel to the street that's 5.6.
Right, and that's just the throat of, you know, I'm not a traffic engineer, so.
No, I get it for the
Yeah.
turning.
It's just, yeah.
Okay. Any other questions for Mr. Romanos? I'm ready for a motion.
Anybody just would like to make a motion, but I have a quick question to Mr. Romano. A bit confused about F1 and F2. You're saying you're okay with those conditions. I know you're not agreeing to F5, which is denial. But I wasn't clear what was being said about the F1 and F2, which is the private tree and the public tree. If I put that condition on, are you okay with that?
Yes, those are appropriate conditions to impose your forestry conditions for city and private trees. Yes, sir. Thank you.
So if there are no further questions, I'd like to move, because this is one of these mind-boggling type of proposals. I don't know how you figure out length with 3 sides determining a property. And your drawing is very clear and very helpful. So I'd like to move, because this is the result of the size of and the configuration of the lot. I think your variances are here primarily. So I'd like to move for approval of variance 1 as revised, 4 as revised, and 5. That's on the revision agenda page. So 1, 4, and 5 on the condition of forestry F1 and F2. And I think those are the 2 conditions, and condition by planning, sorry. It's a planning condition as well. And that is the proposed development should be constructed as illustrated in architectural site plan dated November 10, 2022, held on file by the Committee of Adjustment as it relates to building length.
Thank you, Mr. Bellissimo, for that motion. Just to be clear, we're looking at the revised agenda page. You're not proposing any change to that as it came back to us, right? Because you went through each of the.
Just a revised page. It's the yellow revised agenda page, November 10th.
That's correct. Thank you. Seconder for Mr. Bellissimo's motion. Mr. Kamarik. Thank you. All in favor? Unanimous approval. Thank you, Mr. Romano. Be well. Okay, so we move on to item number 20. The next 4 items are consents with severances, consent to severance, and then related minor variances. So the first of them is item number 25, A, B, and C, 58 MUIR Avenue. It's an application for consent to sever the property into 2 substandard lots. Undersized residential lots is what it's called. And on each side, they intend to redevelop the site of a new detached dwelling with an attached garage, and I believe each requiring 5 variances. We have a draft R plan survey, planning rationale and presentation. Planning is recommending refusal of the application. Forestry is recommending denial of the severance and the variances for part 1. And to deny the proposed parking space, Councillor Perusa is in support and has provided a support petition. And okay, and what else do we have? That's about it. In the additional materials, we have a letter of opposition, 2 of them, 1 from 3 Shamrock Avenue, 1 from 59, or no, that's on the one below that. Sorry about that. So urban forestry, again, condition 1 or a denial. And the speaker for this application is Salvatore Crimi.
Yes.
Welcome, sir.
Good afternoon, Mr. Chair, members of the committee and committee adjustment staff, fellow residents and presenters. Firstly, thank you for the opportunity to present this and hear it. Before you is an application to sever the existing lot and build 2 detached houses. Without trying to draw creative conclusions as I outlined within the rationale support, we do know there is a housing crisis. The owner of the property does recognize that, and this proposal is a response to that. We Furthering that rationale with trying to provide different typologies of housing within the area, if you do notice, both the houses will contain entrances to the basement directly, so that if future prospective owners would like to rent the basement out to provide more affordable types of housing, that's going to be made available. But further, I think the most important thing with this application is, the variances respecting lot frontage and lot area. Part of surveying the community and actually knocking on doors to hear the community's opinion on this application, I was surprised, but there was support from the immediate neighbors. Further, surveying directly across the street, we can look at 81 Apted Avenue, which recently went before TLAB, and that was approved to create the two lots, which are now 55 and 57 MUIR Avenue. Further, if we travel a little bit down MUIR Avenue towards Islington, there was a large-scale residential development that was primarily stacked townhouses. So we can see that this area is prime for intensification. And further on Finch, we have the creation of the Finch LRT, which is going to be finished hopefully soon. I know it's painful now, but there's a plethora of offerings within this neighborhood, even through employment within Emery Village and the plethora of retail amenities. So it's an area that, in our opinion, is prime for intensification to provide that housing, and why this application has been submitted before the committee. I don't want to take too much more time with this because it is what it is. You have the material in front of you, so I open it up to any questions.
Okay, thank you, Mr. Cremini.
Brismo has a question. Have you seen the planning report?
Yes, sir. So
And there's a sentence I want to read to you. The city planning staff communicated their objections to the applicant prior to scheduling of this application. However, the applicant declined to revise their application. Can you explain what those issues were about?
So the nature of that conversation was purely that this was a severance application. There weren't going to be any discussions after that if we weren't going to be willing to modify the application to maintain a single house on the lot. But because it was a severance, planning wasn't willing to have any further discussions after that.
So it's either severance or no severance, basically.
Correct. And
Okay, thank you.
Yep.
So it wasn't a question of smaller lot, undersized lot, undersized house. They weren't just concerned with the size of the house, that it was proposed to be at 38% plus coverage. It was, they just didn't want that at all.
No, exactly. And
okay, my question, you said red neighbors and support. So, are those neighbors, sitting on similar lots, perhaps looking to do the same thing? In terms of I see the councillor I said he was in support, but he just had no concerns. And then we have the support petition. But sometimes when you see a support petition in these things, I noticed, I know I made a note I didn't read. One of the signatories of the support application is actually the owner's son, who has the same name and lives at the same residence. So that name is to be discounted. But, you have some other people who are in support. That's acknowledged. But I would sometimes discount that on consent applications because it says people waiting, wanting to the same thing to go ahead. So not that they're not entitled to vote in their support, be in support of the project for that reason. But in terms of the built form, they're not necessarily agreeing that it's compliant, as the planning department is tasked with doing.
The planning department really didn't comment on the built form.
Okay. But they just didn't want the severance. They thought the lot was, this lot should not be divided.
No, but if we look at if this was a recent plan of subdivision, these would be very similar lots to what would be provided in terms of modern standards.
Okay. The issue is you have one lot, you want to make two lots. So it's not just setting out a new plan of subdivision. That's a little different. Because you look at the prevailing form, if you're not doing it all at once. Any other questions? Anyone have questions for?
I have questions and comments, if I may, Mr. Chair. Yeah. One pertains to build form, and we're proposing 2 new builds here, and we're asking for for exception to rear yard setback. I take issue with that. I mean, you're doing a new building you should be able to comply with the rear yard setback. That's a comment. You can respond to it if you wish. The other observation is the other severance that took place across the street. The two created lots were slightly larger than this one. Again, it's a comment. I think you're close, but anyway. The other thing is I'd like you to address forestry and what their concerns are and why they're suggesting refusal.
One of the, Stan, I don't, by no means, I want to remain respectful in how I'm going to communicate with regards to the rear yard setback in the lot area. We're asking for a 0.2 allowance for the rear yard setback in the lot area. Yes, it's 40 square meters, so it is something that we need to consider, fully granted. The forestry conditions that are the forestry comments that are in front of us, it's regards to where the new driveway is going to be located. I mean, we need to get our approvals in place first before we can entertain those conversations as part of the building permit application. But they're young trees that we wouldn't be opposed to planting 2 trees in place of that tree that's going to be removed.
That's fair about the forestry comments. Thanks.
Okay, any other questions for me? If no other questions, is someone ready for a motion? Mr. Taylor?
Yeah, I'm just, I've done a sort of a Google instant street view scan of this neighborhood, and I'm looking at the location map that's part of the application material. And my concern is the lot sizes, area and frontage are not generally consistent with this neighborhood right now at all. And I appreciate the agent's comment about it being a good candidate for intensification, but it is currently not identified as a candidate area for intensification. It's a single family neighborhood, detached homes with very large frontages and areas. I'm supportive of the Community Planning Department's report on this. The lot sizes are inconsistent in the immediate context. I note that the lot area is just over half that required by the zoning bylaw. And I move refusal.
Thank you, Mr. Taylor. We have a seconder for Mr. Taylor's motion, Ms. Alderson. Thank you. All in favor? Opposed? Motion carries 4-1 with Mr. Komorik dissenting. The application is refused. Thank you, Mr. Crimmy, and don't go away because you're the applicant in the next application, which, okay, I'm going to do an introduction. By comparison, that one was a cakewalk. This is again the 8027th Street, item 26A, B, and C. Consent to sever the property into 2 undersized lots, each to be redeveloped as a site of a new detached dwelling, each requiring 15 variances to the zoning bylaw. We have a draft R plan and plans, cover letter with presentation photos. We have ECS comments. We have a planning okay that they're okay to schedule it, and then we have a planning refusal report. Forestry is looking for conditions 3 and 5 being a refusal. Councillor Grimes, as he then was, recommended refusal. New councillor Amber Morley recommending refusal. 15 letters of opposition and 2 letters of opposition in the additional materials. The speaker, I guess, is Mr. Salvatore Cremini again. And we have 7 neighbors, including Mr. Trolls, registered to speak on this matter. And I'm hearing an echo from someone. So someone has something on. Anyway, I'll turn it over to Mr. Creamy.
Yeah, I just think with the abundance of presenters that they're going to be for this file, the presentation I'm going to make is outlined within the rationale support. It's basically mimic what was said before. So I think maybe it might be in the interest of time, give the presenters by the community a chance to make their presentations, and I can just make one presentation to address all.
Madam Secretary Treasurer, is that permissible? Because typically in the rebuttal, as they say at the outset, you really only asked to answer questions. But had other committee members before you go to staff to see if it's permitted. Is it desirable? Do we want to hear, or do we want to? We've all reviewed the application, so do we want Mr. Creamy to walk through the application now, or forever hold his not do so at the end? Or do we want to allow him to do it all at the end after he's heard from the neighbors? And if, assuming that's approved, Madam Bartosik, is it permitted?
I would recommend that he make his presentation because he can't provide new evidence in his rebuttal.
Yeah, that's right.
And it doesn't give the neighbors a chance to address whatever comments he has.
Right, and I guess this way the neighbors, although I'm sure they reviewed the file, are entitled to hear from him before they make their comments. That's the way things normally work in a administrative law or adversarial system, right? So
just trying to move things along for the committee. That's all. But no, I can make a quick presentation.
Go ahead.
Before you again is a consent application to create 2 lots and build 2 detached houses on each lot. By taking time to survey recent decisions within the past 10 years by the committee, I can draw the conclusion, I'm not going to speak for the committee, that we can see a plethora of recent approvals that show this application in terms of lot area, lot size, and built form do match what the current fabric of the community is. In a lot of the respects, we're larger than recent consent applications because it is it's a decent, healthy sized lot. The area that surrounds this application again is prime for intensification to achieve the targets to provide more housing within the city of Toronto. The homes of essence do that. They are going to accommodate possibly 1 and possibly 2 dwellings within each lot if future owners so do choose to. There again, plethora of options to serve these prospective new residents along with the existing community. And regarding the forestry comments, they were a little bit surprising because we don't show to remove any city-owned trees. There's a driveway that is going to go adjacent to part 2. There's a lot of options that we can do for the driveway as to not impact that tree. Protection can be maintained during construction, and there are no plans to remove that tree nor injure it or remove it. So the abundance of comments, both by staff and by residents, that tree is going to be harmed isn't of the mindset nor the intention of the owners, part of intensifying this property. The built form, utmost care was done to respect neighboring heights and massing. As we can see on the site plan, the adjacent lot already has been intensified and is currently overshadowing the existing house anyways. We're going to be matching the length and depth of what's in place. And further than what's within the rationale support. Again, even the planning report that was on file, again, it was another conversation that because this is a consent application, no discussions were going to be had. So really there weren't any modifications that could have been presented to planning because in essence that it was a severance application, no discussions were going to be had on it. So it was another scenario similar to 58 MUIR. We tried to reach out to the Long Branch Association to actually sit down and talk again because this was a severance application. They didn't want to have any discussions. In all fairness, a consent application is submitted within this neighborhood. It's a stacked deck, but intensification ultimately is required across the whole city. And this is an area that's really prime for it because of its proximity to downtown. So I open it up to presentations by the community members.
Thank you for that, sir. Similar approach to your last application. The question is here if they wouldn't discuss it, so you decide, okay, not only will I go back and proceed with the severance, but if in terms of variances, I won't do semis. Sometimes they like semis. I won't go in with a reasonable FSI. I realize that lot's the lot. I won't go with a reasonable. So you decided to shoot for the moon as well as try to get the severance when they clearly told you the severance. So again, I was going to ask you, like last time you don't know what they were opposed to because they wouldn't go past the severance, but surely you got to figured that these numbers were high.
Mr. Chair, without most respect, not more than half, but a good portion of the existing variances are really close to the existing zoning bylaws that govern the property. And then a lot of them pertain to it being a severance in a smaller lot. In essence, it's an ill of intensification that I think within the coming years, we're going to see more of.
Okay, you're 3 meters over in your length at 17 meters.
I didn't say all, I said half.
Okay, I'm just saying half of them, but the big ones, the ones that make a difference, the floor space index and the depth and the height. Well, height, you're barely over. But let's be reasonable. Small lot, a severance is more of a privilege than a right. When you're trying to create a new lot and then you're trying to stuff that lot. But it's your right to do so. That's all. The committee
Ismo has a question of the applicant when it's time.
Go ahead.
So you said you reached out to the neighborhood association, did not respond. Did you reach out to the adjoining neighbors and across the street?
No, sir.
Okay, thank you.
Okay, so unlike the last application, we didn't have anyone present. We have 7 people registered to speak. So the first one is the neighbor at 81 27th Street. And her name is Heather Haslam. And again, we have all the letters too.
Mr. Chair, we do not have Heather on the line.
Okay, so let's do an attendance sheet before we go further. Are all the rest of the people present, or do we have any that have dropped off?
All right. We had Michelle Flynn on the line. She's no longer on the line. Sam Simerda is on the line. Andy Choles is on the line. Jason and Robin Hewitt on the line. We have David Ilsey on the line. Vanita Indui, she is on the line. Sharon Heaney is on the line. And our final speaker is Barry Breeze. You may not have that on your list there. It was a It was a last minute registration, and he is on the line.
Okay, so we have 1, 2, 3, 4, 5, 6, and then I'll put Andy. Likes to go at the end. I can accommodate that. Let him flat back clean up. I'll just when we do hearings. Hopefully, we're going to go back soon to in-person hearings. When we have everyone in the room, we get people, the objectors, they get together, they discuss it. They usually appoint 1 or 2 spokespeople. I'm not requiring you to do that, but just keep in mind where this application, you don't have to use your whole 5 minutes. And so let's go through the list. First one, I guess, is Sam Simerda at 82 27th Street. And again, depending, some neighbors are much more effective being, let's say, right next door, right across the street, than someone a block away. But you're certainly allowed to give us your views, but there are a lot of speakers. Thank you.
Absolutely. Thank you, Mr. Chairman. So this is actually Jessica Simerda, Sam's wife. He had to jump onto a work call, so I'll be speaking on behalf of him, and I'll keep it quite brief because I know we do have quite a few of the neighbors on the line, and I'm sure we all share the same sentiment. So in terms of this application, we have a very similar lot next door at 82 27th Street. We were also in a similar situation where they attempted to sever the lot. And we're very happy that they did not, because my husband and I have now moved into the neighborhood. And I think it's a great representation of how you can maintain the character of Long Branch, but still keep it to one home and not squishing 2 houses onto one lot. So that would be kind of the biggest example of how this can be appropriately done. The second piece is that 80 27th Street is very much an abnormal lot in that it's at the corner. So it will really be robbing neighbors such as ourselves, but even more on the other side of their privacy in their backyard, in their second floor, their first floor. It's completely overcrowding the backyards. So it would be a huge issue for us in terms of privacy. And lastly is around the parking and the street, crowding the street there. It's, again, this abnormal lot. So we're on a corner. There's lots of children in the neighborhood. Cars very frequently speed through that corner. And to now have 2 homes there, we're increasing the amount of cars parked on the street, the amount of traffic in that area, and that would not be advised for ourselves as well as others in the neighborhood. So I'll leave it at that and allow some of the others to speak as well.
Okay, thank you, Ms. Samerda. Thank you for your comments. And you're right next door.
Yes, we're right next
And
door.
you're someone who was able to buy that house or maintain that lot and live there without having to sever it. And the trouble is often people like you are outbid by builders who plan on severing the lot and making more money so they can offer more. So nice to see that you've been able to do that.
Thank you.
Any questions for Ms. Samerda? And if not, let's go to the neighbor on the other side, Jason or Robin Hewitt at 78.
Thank you. Thank you very much. So sound check, can you hear me okay?
Yes, perfect. Yep.
Okay, very good. Just a point of order. My wife wanted to speak about the Long Bench Garden Show and our display in our garden. Are we both allowed to speak and use the 5 minutes, or is it
No,
only me?
no, sir, only one, and we only want to hear planning issues.
Okay,
so
fair enough.
Thank you.
I've noticed okay. Thank you for resetting my time. So thank you very much, Mr. Chairman and Committee of Adjustment for allowing us to share our thoughts on what we believe to be an absolutely egregious application, consent to sever, and related variances. So I believe it was mentioned a few moments ago about some of the documentation and voices from the neighborhood not in opposition of this application. So I will say that a petition has been circulated throughout the community within the neighborhood. 80 people have signed it, including all houses adjacent to this property. So there's a ring around this house where they have signed. It's also been mentioned that 17 letters of objection have been sent in by the neighborhood. Councillor Grimes sent in a very strongly worded letter opposing this application, as did Councillor Morley, who had only been in office for a couple of days. She felt strong enough that she would also write a letter in opposition to this. Toronto Planning, of which I've been speaking with the planner that wrote the report, has a strong recommendation for refusal of this severance, as well as Toronto Forestry is also recommending refusal of all three applications. I will point out, although I'm certainly not an expert, that I did not notice that the public tree in front of the house was disclosed on the affidavit. So a bit of a question mark why that was left off of the application. And now sort of speaking to more of how this will directly affect our family and with respect of our other neighbors, we are probably the home that will probably be the most affected by this if it is approved. So we are asking that the committee refuse this application for consent to sever and the minor variances associated with building two non-bylaw conforming long and tall houses on one lot, including designs encompassing two stack levels of a very large above grade decks. The design of the decks is also the first floor is quite a distance off of the ground level because of the integral garage. Quite frankly, our family is absolutely horrified, and we don't use this word lightly, by these development applications. I was hoping that you do have my letter up. If you can move to Appendix 1A. I included some pictures here. And as they would be detrimental to our enjoyment of our property and that of our neighbors. So the proposed design of non-bylaw conforming long and tall buildings will create an imposing brick wall that will completely block out all views of the neighbor shared green areas looking to our backyard and to the north side of our property. And we are a bit of an interesting placement of our home. We are sort of a corner lot. So the red line that I drew there essentially shows where the long and tall building will be placed, including the stacked decks in the back of the house. So it will span the entire width of our backyard and the entire width of the rear of our home. We are most distraught. If you can actually move down to Appendix 2, please. We are incredibly and seriously distraught about the blocking off of our 7-year-old daughter's bedroom window. What you see here is a view across the shared green space. The home will be built in a way that there isn't a garage on the property right now. Roughly, the home will it's 66 centimeters off the property line with the drip line of the roof directly on the property line, will completely block off all of that space. I hope that the committee really does take this into consideration. So the brick wall will also block all views from our grade level patio. So our patio is actually right next to where that sort of ground level garage is. So again, there will be a very long and tall brick wall that will close off all views of the shared green space. It will also close off all views and destroy our privacy to our second floor north facing master bedroom and bathroom window at the rear of our home. And will also close off and block off all views and destroy our privacy to our first floor north facing dining room window. We also feel as though the proposed applications do not fit with the character of the block. We did reach out to the applicant to talk to him. We are in support of development in our area. We were directed to a lawyer's office. We gave all of our contact information, and no one from the applicant returned our phone calls. Which we actually applied for variances to build the second floor of our home. We worked with all of our neighbors. We talked with all of our neighbors. They were all in support. So when we went through a similar process as we're doing today, all of our neighbors were in support. Thank you for listening to our concerns. The rest of our concerns are in our detailed letter.
Yeah, thank you. Very detailed letter, and the pictures are fabulous to have. And again, you didn't split your lot in half. You built something that was acceptable on the full lot.
Yeah.
So, you mentioned, just want to point out Councillor Green. Yeah, he used the word egregious, which I don't normally see in council letters. So if anyone have any questions for Mr. Hewitt? And if not, and I think we've now heard from the two most directly affected neighbor on either side. We'll perhaps the other speakers can keep that in mind in terms of their comments and the brevity or length thereof. So next speaker, David Hisley.
Can I actually just say, I know Michelle Flynn has called back in. I think at the beginning, it was said that she dropped off, but she's called back in.
Okay.
Thank you.
She's an area resident. Looks like she lives on Lake Promenade in a condo. But anyway.
Yeah, and David Isley at number 1 Shamrock is also egregiously affected. He's directly next
so we'll hear.
to.
Yeah, everyone's going to get a chance, but
okay.
Is Michelle Flynn? She was first on the list. I don't know where she lives in relation to the property, but I guess if she's back on the line, she was number 1 on the list. So I don't know how you know she's back on the line. The staff didn't.
Yeah, Michelle's on the line and she is unmuted.
Okay, Michelle, let's hear from. Please let us know where you are in relation with your interest in this application.
Good afternoon, and thank you for hearing me. My interest in this application is because I've been a resident of Long Branch for 50 years.
Okay.
I've watched what's happened in this area. I've lived on that street. And to see an application such as this be put through is extremely disturbing for the neighbors
just
involved.
need your address for the record.
It's
I'm
on
at 220 Lake Promenade.
It's on the list.
I know we just need it for the public hearing.
Okay. Thank you. You know, if you've been listening and you know that there is a lot of opposition to this, appreciate your participation.
And I just want to be here in support of the neighbors as well, just to let you know that this type of application is extremely greedy and it will negatively impact all the neighboring homes, their privacy, and their enjoyment of their green space. It's very unfortunate that these type of developers come into these areas and buy up these desired properties and try to desecrate them without taking into consideration the character of the area. As you can see, the house that they want to build, the 2 houses are very large, very imposing. They will take the natural light away from the neighboring homes. And as Jason admitted, that it will be a very impactful problem on his property, which will no longer just affect his family, but it'll affect all the property values in the area. As well, sorry. I won't go on anymore. I've said my piece. The neighbors that are surrounding the home are going to hopefully make a wonderful impact on this application. And as you can see, it's a negative application. It's extremely, as Mark Grimes did say, egregious. And it's a very greedy application, in my opinion. Thank you for listening.
Thank you, Ms. Flynn. Just lost your point. I was, before the staff asked to give your address, we already had, you said something about you're, disturbed seeing us put through this application. This application only gets put through when it gets approved. In terms of taking in an application, someone can submit on anything and
whatever they want,
take it in. So things don't get put through until they're approved. So, anyone can put in an application for anything. So we've heard a lot of people. We have a few more to hear from. So the next one, thank you. Next speaker is again someone, David Isley, who's also really affected. If you look at the location map, and see where that property is located. Welcome,
Mr.
sir.
Chair, can you hear me?
Yes, loud and clear.
Yes, my name is Dave Isley. I live at number 1 Shamrock Avenue. I'm right next door to Mr. Hewitt, and I'm in the same boat. I don't want this two-house application to go forth. I support the development of one house on Mike's lot with conditions, no balconies. Mr. Hewitt said it beautifully a few minutes ago. He covered just about everything I would want to say with regards to the problem that we will have if this goes forward with those balconies. I do not want balconies on any house being built on Mike's lot. The balconies would block my view, and I don't want this. I want an open feeling in my backyard. I do not want two houses built on Mike's property. I have no problem with one new house on Mike's lot, as long as it's done properly and within the proper guidelines that everybody's happy with. The balconies have got to go. They'd be looking down into my house the same as they would with Mr. Hewitt, and I don't want this. I am asking that the committee primarily refuse this egregious application for severance and the minor variances associated with the building of two long and tall houses on one lot, including the designs encompassing 2 levels of the above grade decks. I can't make it any clearer. I think all of our neighbors have said the same thing. We have no problem with people moving in, building a house, as long as it conforms with the other houses in the area. But when you start doing balconies and decks that overlap into people's backyards and cutting off light and that, no. As I said, I have no problem with development, but I don't like what I'm seeing. And as Mr. Hewitt said beautifully, this cannot go ahead, and I can't make it any plainer. And I thank you for taking the time to listen to me.
Thank you, sir. Be well and just stay tuned. We'll have a few more people, and we'll be making a decision on this. Next speaker is Vanita Indue at 59 Ash. We have a letter, also in the additional materials. I believe it's exactly the same letter. And welcome.
Good afternoon. So you have my letter. So I'm going to just speak to a couple of things that the applicant said and not address, I think, the very heartfelt comments that the neighbors have made already, and their experience is the one that we should be listening to here. So I live in the block one up from where this house is on Ash Crescent, and I have opportunity to go past this particular house twice a day, walking my dogs. And so I'm going to speak a little bit from the broader perspective of the neighborhood. And one is, the applicant references previous committee adjustment decisions supporting these types of cases. But we know from experience in recent years that as those cases go forward and the neighborhood recognizes what has just happened, that the majority of those get turned down, at an overwhelming majority of those. I think it's 29 out of 31 get turned down at TLAB. Because the neighbors are attracted to the neighborhood for the same reason that new people want to move into the neighborhood. It's the trees, it's the green space, it's the sense of privacy. So this design and this lot splitting activity is a part of a trend that has happened over time, decision by decision. So when the applicant says that this type of development is acceptable because it provides affordable housing, that it provides housing that the city wants, the word that's left out is affordable. You all know what's happened to the housing prices in Long Branch. And this particular intersection is a perfect example of the impact of these trends. Shamrock to the south has largely turned over in terms of home designs in the last, I'm going to say, 5 to 7 years. There's currently a lot on Shamrock, just 5 homes away from the applicant's property, where the developer has bought the lot, got the severances, and now has it up for sale. And it's been sitting empty for quite some time, waiting for somebody to buy it with the applications. Across the street and to the south are 2 more developed lots at 73 and 75. And in this case, those homes were built with the condition that the tree would be protected and not harmed. And at the point when driveways and access had to be done, the builder took down that tree, paid the fine. That was no deterrent. And I know that you're savvy about looking through Google Maps at what these homes look like, but when you look at this home, I cannot imagine how 2 driveways and 2 homes are going to protect that tree. This tree has this lot rather has a tree planted in the front that is a string of properties on the same block where the city planted trees of a similar size and position in each of these front yards. They create a green overhang on the walkway, which is a key feature of the street. You take out that one tree on that one lot, and then the next developer who comes to you is going to say, well, we did it there, and it's a part of the trend. It's only a part of the trend if we keep approving them. And I think removing that one tree will open the door to the argument of the next developer. So, I mean, the picture there, it's hard to imagine how that tree will survive. The block that I live on Ash Crescent, has had several developments of this sort, and the trees never survive. They might take a year or 2 to fall, but they don't survive the construction. They don't survive the root damage. And this is why forestry weighs in, and we count on them. The other comment that the applicant made about overshadowing, etc., doesn't reflect the nature of this block. As you can see from what the neighbors have said, they're all on a curve. It's an unusual intersection. You wouldn't want cars parking on the street there. And this is what happens when you put a large overbuilt home on 2 lots with access to a single garage. Somebody ends up parking on the street, so you don't have to juggle. So these are all things that I've experienced on my block. I see it happening on other blocks. So from the broader perspective of the neighborhood, I think this would be a bad decision. So I want to thank you in advance for protecting what everybody wants to buy and encouraging them to move into lots that are not split and that are not overbuilt home designs.
Okay, thank you, Ms. Indeway, for your submission.
Thank you.
Our next one is Sharon Heaney. We don't have an address for Sharon Heaney, so we'll need that.
Can you hear me?
We can now, yeah.
Okay, perfect. Yes, my address is 3 Jasmine Avenue. I'm 1 block south. So Shamrock is the street north, and I'm on the corner of 27th and Jasmine Avenue.
Okay, yeah. Oh, your neighbors with Andy.
Yes.
Okay,
Yes.
go ahead.
We're on the same street. Yeah, yeah.
Okay, go
But
ahead.
don't hold that against me.
Remember, please try to make your comments brief if possible.
I will, absolutely, because everybody has said what needs to be said. My comments actually relate a little bit to the previous speaker. I just wanted to bring everybody's attention to the number of trees, the number of protected trees that have been lost on 27th Street. Starting at the bottom of 27th Street, we have had developers promise to protect trees, and we have probably lost I would say 7 or 8 trees in between the Lake Prom and Shamrock. So the promises to protect these trees are very much idle promises. Those trees do not get protected, and they are very much destroyed. My kitchen window view now used to have a huge walnut and a huge sugar maple, and those trees no longer exist. Apart from that, I'm just want to reinforce all the comments made by the other speakers. And that's as brief as I can be.
Okay, thanks, Ms. Heaney. Appreciate it.
Okay.
Next speaker is Barry Breeze, new addition to the list. We'll need an address as well.
Barry Breeze here. Can you hear me?
Yes.
Thank you very much. If you can hear me, that's great.
Is okay. Do we have? I think we put a letter on the board. Is that your letter? Get an address.
My wife wrote a letter. That's correct.
Okay. Under that tab, I have a different letter. There it is. Leslie and Barry Breeze. Okay.
What is your address, sir?
My address is 77 27th Street. I live directly across the street.
Thank you.
From. So anyways, I have several talking points. I'll try to make them brief. I've been a long-time neighbor in this specific little area that I live in. And just to give an overview of the neighborhood, our neighborhood was designed for 50 by 150 foot lots. And a lot of what is relevant to the street plan in our neighborhood is Arcadian Circle and the streets that project off of it. And Jasmine and Shamrock come off of Arcadian Circle onto 27th Street. And giving a little bit more history, I've been here on this property for 29 years. And when I moved in, it was always my intent to do something with the existing house, and I put a second floor on it. And I did that without the need to go to the Committee of Adjustment, let alone the Ontario Municipal Board or TLAB. It was just a straight thing. I put the second floor on, increased the size of my building, and I see that that's still being done on our street. 102 27th Street has just put a second floor on without having to put the entire existing house in a dumpster and send it off to the landfill. Your average family cannot buy a house on our street anymore. The developers who come into the neighborhood, and might I say greedy developers, they're only interested in one thing, and that's squeezing every last dime out of the property that they bought. And, you know, if I was a developer, well, that's what you do. It's just your game plan. So somebody thinking that they can buy a house in this neighborhood, the developer is just going to outbid them. And all of this is very stressful. You know, when you live in a neighborhood that you think's a nice, quiet neighborhood, the developers think that it's their neighborhood. Oh, this is an opportunity to make money. Nobody's, I can't say nobody because I saw 102 get a second floor on it. I don't know all the particulars of that, but I know other builders have had to go to building just a single family house and have made lots of money doing that. So I just don't get the whole point of severing properties when you can, as a builder, you can make reasonably good money without having to sever it and build two houses. And I feel that there's that this developer in particular, with all his minor variances that he's putting forward, are just disrespectful to the bylaw. Like, what is the purpose of all of this? I think it's just to I don't know how to clearly to say it, but it's just
I think you've made your point. You're over 4 minutes. I would respectfully.
Okay. I'll just make my last point then.
Thank you.
The previous owner of this property, his name is Mike Flynn, and he went out of his way to stop the lot splitting in this neighborhood. I have a sign on my front lawn that says "Stop the lot splitting," and he gave out 400 of them in this neighborhood. So to me, it's just complete disrespect to Mike Flynn. He's no longer with us, unfortunately, and you've already heard from his daughter earlier. So
okay,
I'll leave it at that. Thank you very much for your time.
Yeah, okay. Thank you, sir. You were very effective right across the street, but I would certainly request that the remaining speakers please try to be brief. This is a public hearing. It's not a conversation, and we have a lot of hearings, applications left to go, and we'll be going into the evening. So it appears to clear where this application is going. I know it's emotional to people. And like I said, the city staff has no choice but to accept applications. And unfortunately, if applicants want to come in and pay the fee, city staff has to take their money. So notwithstanding, this application seems really on the edge, the extreme of the continuum. We just ask that you please try to be brief, the remaining speakers. Mr. Breeze obviously was right across the street, most affected, along with the Hewitts and the Simurdas. So the next speaker, I believe, is, I believe we're down. Oh, I believe we only have Mr. Scholes left. Welcome, Mr. Scholes.
Good afternoon, almost evening. I'll be in exhibits. Hello?
Yes.
I'll be referring to a letter of objection and exhibit submitted by Christine Mercado, the chair of the LBNA, page 2, 7th item in the list of AIC document.
Okay, it's item number 9, opposition letter 9 out of 15 or 17.
Should be the other one, the one that's 13.7 megabytes in size, the exhibits. That's the one from, that's the one, yes, okay. Good afternoon. My name is Andy Scholes. I live at 12 Jasmine Avenue in Long Branch. I'm a member and sit on the board of the Long Branch Neighborhood Association. I have a mission statement to protect, celebrate, enhance the neighborhood of Long Branch. I live a block or so from this home. The LBNA is requesting this application to sever the lot and build 2 oversized soldier houses on each half be refused. We do support renewal of housing stock in our neighborhood, but design elements need to recognize and enhance the character of the neighborhood. These homes do neither. The neighbors have very well expressed their dissatisfaction living next door to this monolith of a house. I will direct my attention to the applicable decisions in the area and also address the report from Relic Creations regarding this build. I would hope that you would review all of Ms. Mercado's exhibits. They are very, very relevant, and I cannot cover all of them in my 5 minutes. I would refer you to page 2 of Ms. Mercado's letter of opposition. This applicant proposes to sever this lot, which will impact a mature and very healthy city tree. There have been no severances in the immediate context of this lot since the Long Branch Character Guidelines are introduced as clarification of lot configurations complying with the official plan, Chapter 4.1.5. Ms. Mercado points to 82 27th Street, right next door to number 80. You heard from that neighbor already. It had earlier a request to sever, was refused by the OMB in 2014. I'm not a particular fan of the OMB, but this particular decision was music to my ears. The severance application was refused twice before it finally, the applicant finally settled on a single larger house to be built on that site. 83 27th Street across the street also originally asked for severance, which was denied. Later, the applicant settled for a single house with an enhanced FSI. 99 27th Street across the street a little further north had its request to sever the lot denied at T-Lab. They too worked their way through the system and eventually settled at COA to build a single house on a single lot. Incidentally, the Relic Creations report by Mr. Karimi lists 9927th as an example of precedence in the area. The severance was, I assure you, refused, and a single home is under construction as we speak. In the broader geographic neighborhood, 9 Atherton, 11 Shamrock, 90 Ash, 54 Ash all had applications to sever lot and build 2 homes with integrated garages, all refused at hearings of TLAB 01B or Committee of Adjustment. Any severances that have gone ahead in this area prior to the Long Branch Character Guidelines have failed to result in any additional affordable housing. This applicant has failed to submit the required Long Branch Character Guidelines. This might offer them some clarifications of the policy of the official plan. In reference to the Relic Creations report prepared for the applicant, the report fails to provide any evidence that this build will produce any housing that is actually needed in Long Branch. At present, Long Branch is almost evenly split between rentals and homeowners. This report doesn't seem to have any knowledge that the Long Branch growth plan exists that focuses the density along the avenues, namely Lakeshore Boulevard, and 3 site area specific plans. The report fails to acknowledge that Long Branch is not a designated urban growth area. The examples of precedent cited by the report, they present a plethora of problems, to use Mr. Creamy's word. Ms. Mercado outlines that the issues on page 3 of her letter points out numerous errors. The example of property being out of the area, not being severance applications at all. Others are severance applications that were refused. FSI numbers skewed due to top of bank issues on a lakefront property and the destroying of trees. I'd like to drill down a little bit on this final area of tree destruction. Number 2, 27th Street down at the bottom is listed as item J in Mr. Cremini's report. This is actually 2A and 2B, and there was another severance created to create 4A and 4B. There's a picture of 2A and B on page 22 of Ms. Mercado's exhibits that shows a very large tree that used to be in front of the house. This very large tree would take 2 or more people with their arms outstretched to get around the trunk. You can see also from the photo further down the next page, the tree is now gone. There's a similar large tree across the road at number 9 27th Street on page 26 of the exhibits to give an idea of the size. The large tree at number 227th was the last tree to be removed. This was done after the build was complete due to its, failing health at that point. This was the last tree of a small forest of trees that were clear cut from the sites to build 2A, B, and 4AB. These applications were approved prior to the Long Branch Character Guidelines, courtesy of the OMB. I'm concerned that there's a similar tree, not quite as large, in front of 80 27th Street that seems to be in the plan to destroy. The comments of Mr. Cremini that there's no plans to harm the tree. We've heard that before. Exhibits also further down in Ms. Mercado's submission shows numerous cases where trees have been destroyed after the fact when the house has been built. You have 17 letters of objection at last count, plus a few petitions speaking out against the build. You have 2 councillor letters, one from Councillor Grimes, one from our new councillor Amber Morley. There are 15 variances that have not been met.
Mr. Chair, we're almost at 6 minutes. We're almost at 6 minutes now.
I have 1 paragraph. I unequivocally ask you for this application to be refused. One last comment about the report. Mr. Creamy should really hire a proofreader. I hate to seem mean, but as a retired teacher, in me burst out as I read the report where the author wrote words that seemed to oppose his position. One sentence in his concluding paragraph spoke my thoughts completely, and I quote, "Further, utmost care was taken regarding the massing of this proposal in contrast with the surrounding neighborhood to ensure its appropriateness and respect for the surrounding neighborhood. Since utmost means furthest from, I must agree this application is furthest from appropriate or respectful for the neighborhood. Please reject this application."
Thank you, Mr. Scholes. Mr. Scholes, I think there's enough meat in this without going after Mr. Creamy on his grammar. But I want to, again, we've spent a lot of time, and it's fortunate that we can't schedule separate hearing dates for applications to take over an hour, but we've got to go through. If this was in person, perhaps it could have been truncated, but obviously he has a lot on his plate to show us, and perhaps I'm going to suggest to him that he think about what applications he brings before the committee. So does anyone have any comments for Mr. Scholes or any of the other 8 or 9 speakers we've had? So if not, we'll go back to Mr. Creamy. Mr. Creamy, I have a question for you. A professional planner? Mr. Creamy?
I was muted, Mr. Chair.
Thank you. Just want to know, are you happy to
I-
be a professional planner who's, you get someone else's advice in bringing these applications?
Let's outline one thing. If we want to refer
Yes.
to the application form, I'm not the applicant for this file. I'm a
No, I
presenter for
understand.
this file. Secondly, I attended urban planning school at the University of Ryerson, and I'm not a practicing planner.
Okay, thank you. Just
Nor did I outline and profess to be.
okay, this is a second application that seems you should just think about. I can't tell you how to run your practice, but think about your reputation with city staff and the committee. So please respond to the concern raised by the many speakers and the many letters about splitting this lot.
Staying logical.
And the variance, please.
Staying logical. Listen.
And if
Staying
you need more than
logical.
5 minutes, if you need more than 5 minutes, since we've had so many speakers, you can speak longer. If you,
No, I don't think we need it. Like staying logical with the application. I do respect that this is very emotional for the community. It was a foremost member.
Yeah.
Mr. Clark, I'm trying to speak.
Go ahead.
It was a foremost member for LMBA, and it is respected that this does ruffle some feathers for the community. It's not appreciated that personal attacks are done to further the points, nor is it appreciated that lying is done. So what's before us is fact. The application that I referenced within the reports were obtained through a paid research request portal, and they were provided to me. So I didn't stretch any truth from anything.
Okay. So please go ahead with the rebuttal. I'm sorry if I insulted your integrity, but I'm just trying to give you some helpful advice. So please.
No, I appreciate it, and I do respect that this is an emotional one. So I'm not taking anything personal.
Just for the neighbors, just think when you put an application in and it's guaranteed not to succeed, you may look at the emotional. They have to put letters together very quickly, which they do, and get together. So just maybe think about the reasonableness of your applications. I understand they're not your applications. You're not the applicant. You're a spokesperson. Thank you. Please go ahead.
If we're throwing around recommendations, maybe when an applicant does reach out to a neighborhood association to sit down and discuss the application, they do such and not refuse it. So that maybe could have been worked out before this hearing.
Oh, let's go back to the your rebuttal on the letters and the
transportation comments were brought up. We have support from transportation. So it is granted though 2 houses are going to be created. There is the possibility of excess cars on the street. That would be the fact of the matter if just a single family house was developed on the property. We heard constant reports about the trees. Right now, no plan does show to take the tree down. It's adjacent to the proposed driveway. Protection is going to be proposed around it. No plans to take it down. But I get where the community is coming from. They've seen time and time again trees taken down. So I do understand where they're coming from. And I do feel for the neighbor at 78. But the fact of the matter is the orientation of the 2 properties. The depth variance for what's before you is 0.2 above what's allowed by the zoning code. So even if a single family house was developed, I think that issue is still going to be present for that neighbor. So, but I do sympathize with it, and I'm not trying to shove anything down anybody's throat either. And listen, I think we all know where this is going. I don't want to drag it out, so I leave the committee to make a decision.
Okay, thank you. Any questions for Mr. Creamy? And if not, is someone ready to weigh in with a motion? Mr. Taylor?
My thinking on this one is similar to the previous one. Again, I did a little Google Street View tour, looked at the location map, found the lot sizes, particularly the frontage, to be totally inconsistent in the immediate context. And as a matter of fact, the community planning staff confirmed that 81% of the lots in the immediate context, 30 of 37, have frontages of 15 meters or greater. And one of the neighbors commented that this neighborhood is comprised mostly of, he said, 50-foot lots, which is 15 meters. I think the fact that the small lots create a situation that in order to accommodate the desired house size, the FSI requested has to be 2.5 times that permitted. I'm very sensitive to the fact that people have a right to expect in reviewing zoning bylaws in their neighborhood. They have a right to expect what is reasonable to expect to be built in their neighborhood. And I just don't find this proposal to be at all consistent with the zoning bylaw. I find the variances to be anything but minor. And I can't recommend approval. So my motion is to refuse.
Thank you, Mr. Taylor, for that reasoned proposal. Do I have a seconder for that?
Danny Bellissimo seconds the motion.
Okay, thank you. Before we vote, I just want to point out I was not intending to be, it's not emotional for me. I only read the application yesterday, but it's for the many neighbors who have to spend time and the anxiety for elderly people and younger people to protect their homestead. In fact, to put together long letters and take pictures and do research in a very short period of time. Just think of the impact. So all I'm suggesting is if you want to have a good reputation, Mr. Cremini, among members and among staff, you got to be, or, you can tell your applicant that you're not willing to go in with a certainly very egregious application because it's your reputation on the line as well. And I don't mean to be disrespectful to you. So all in favor.
Can I just add one quick note?
Yes.
In support of what you've been saying, Mr. Chair.
Yes.
We have to await a vote on this, of course, and I'm not presumptuous. I certainly don't know everything about everything, but I expect that the result of this deliberation should have been, in my opinion, very predictable.
Mm-hmm.
That's all I have to say.
Yeah. In a court of law, they say, oh, we don't have to hear from you, but here we have to let everyone have their peace. And when something this comes before, and this is people's neighborhoods and their homes and their trees are very important to them. I've been doing this a long time, and someone's been accused of being pro-development, but let's be reasonable. Whether it's a bad application or a good application or one that has to be fought on it's a close one, the neighborhood still has to come together as they've done here. So I think Mr. Cremini, and more importantly, his client, clients or various clients should think of that. And I'm sure certain applicants would say, I'm not coming forward with that application because I don't believe in it and I'm not going to affect my own reputation. So I was just trying to be helpful to Mr. Cremini. We have 2 applications that have taken us almost over 2 hours. I'm not sure of the timing. Staff can perhaps confirm that. So anyway, let's move on. And again, everybody else behind has to sit and wait, which, people, anyway, the application has been refused. I'm sorry.
No, we have a motion to refuse in a second. We haven't had a vote.
We haven't had a vote.
We just did, yeah. After my
All in favor? Okay,
favor, yes.
Unanimously. Thank you.
Thank you. Okay, our next application, which is also a severance, is 5 Verona Avenue. It's 27 A, B, and C. The applicant is Bruno Lopez, and we have an area resident from 17 Buttonwood. But just to do a brief introduction of this application, it's to consent to sever the property into 2 undersized residential lots, each to be developed the site of a new detached dwelling with an attached garage. And I believe in this case we have how many variances? Yeah, there's a slight difference. One has 5, one has 4. The retained lot 5, the conveyed lot 4. We have the ECS. We have the applicant's revisions to plans with no changes to the variance. Planning is recommending refusal of the application. And forestry is looking to have it deny the severance and deny certain of the variances set out in their memo, looking for conditions 3 and 5. And so we'll turn it over to Bruno Lopez, agent for the applicant.
Hi, Mr. Chair. My name is Bruno Lopez from Excel Engineering, and I'm the representative for the applicant. This is sort of a long story application. This homeowner has been living on this property for 21 years. So no wonder that there is no neighbors involved here coming against this application. So in a nutshell, we're trying to divide this lot in 2 to build 2 new homes, and reasoning the owner of this property still has 2 sons So the idea, in fact, will be to build lot 2 first, and after lot 2 it's done, they can move in and they can build lot 1. We understand. I had a couple conversations with Daniel from planning. I understand where he's coming from. He's trying to somehow show that, you know, we are undersized in terms of lot. Due to the situation of the lot being a corner lot, is very unique, and there is no way to actually fight the setbacks, the rear and front. However, I would like to point out that we have very wide side yards. So it's like if we could rotate the houses the other way, we would be pretty much almost compliant. We are aware about transportation. We are aware about engineering. There is one comment or one of the variances, which is the parking space being by a flank street. But if you see this street is like a U-shaped street, right? That goes from Verona, turns into Emmet. So it's one situation that we see it all over. Even the other houses, they have the garages in the front. So I believe this one is mostly a technicality. In terms of the lot being a little bit odd, it's going to be pretty much a rectangle, other than usually a long neck rectangle. But we have a situation that it's the right, just abutting to my client's lot, which is on Emmet Avenue, number 60, 62, and 64. If you see to the right of our drawings there, you see that it's a triangular shape. So there are 2 triangular lots, and one is like a trapezoidal shape. So it's a little bit odd, yes, but the neighborhood is it's pretty well established. I don't think we are doing anything obnoxious. We're just trying to build 2 modest homes. They are about 2,000 square feet, including the garage. And again, we didn't change GFAs, FSIs, heights. So we try to model something that will be modest and look alike to the neighborhood.
Okay, thank you, Mr. Lopez. I just want to, so can we get the location map up on the board? So basically, I think community planning reading, they're concerned that the fact that you want to make 2 squares, like splitting it on the side street as opposed to down the middle lengthwise, and they feel that's a bad precedent and the lot is substandard. Would you agree with that's their basic position?
Yes and no. And the thing is, again, Mr. Chair, with the conversation with planning, I told him that we could go a route of doing a bigger house and a laneway suite, which would be allowed, but it would be very unfair for the 2 sons that this good father wants to leave the houses for their sons. One will have the little one will have the big one, would be unfair. So with the opportunity to create some balance, make it look alike and fit more with the neighborhood, right? Otherwise, we'll be building a big Goliath that usually it's allowed, plus a laneway suite probably will be not as pleasant for the neighborhood.
Well, good thing you didn't have 3 sons then, I guess, right? You'd be asking to split it in 3.
I guess so.
Only
And the intent
only,
again would be to build one, move into one, and then build the second one, because and coming back to the comments from the city, the city trees, no, the trees are to be preserved. If you see the drawings, we strategically located the walkways and the driveways so we can protect the trees. Will be some damage, yes, we have to apply for a permit to injure, but we'll try to save the trees to the best of the ability.
Yeah.
Even a city utility, there is a new utility pole right now that we're gonna leave it in place. We work everything around to make everything fit.
Yeah, and I agree. You only have a couple of variances. They're not huge compared to some of the other applications we've seen this afternoon. But the main objection, I'm just asking, I'm not saying I agree, but if you agree with me, the community planning seems concerned because of the way you want to split the lot here. Obviously,
correct. But the other way around would be even worse, right? Because I'm splitting in half, not lengthwise. So the other way will be not possible at all.
Exactly. You said it, not me. Members, any questions for Mr. Lopez, or we'll hear from the neighbor at
Danny
7?
Bellissimo. Danny Bellissimo has a quick question. I read the planning report, but I've also listened to your very interesting presentation. Those 2 properties, if they're consented, will be looking onto a large view is that a ravine there, or what is that? That drops down, correct, or it goes up?
Yes, this is a sloped street, but the view actually is going to be to a 22-story building. Because the other side of the street is a 22-story building. Actually, there is a few buildings.
Sorry, no, I'm talking about the open view between all the buildings. There's a lot of terrace going on there.
There's some open space in between the tall building and the.
Yeah, so you're basically, the front of your two homes would be facing south, is it? And onto a large open space, okay.
Correct.
So I don't agree with planning in their report, because I think this is a unique situation. I think that the impact on neighbors is minimal, if not zero. And, you know, we're pushing small homes in laneways, we're pushing small homes in rear yards. And so if we're going to be pushing small homes, I think there's one location that I think we should be agreeing with. I call it a small home because the footprint's small, but it's 3 stories.
Yeah.
So I understand that. So I just wanted to clarify that. And I'd like to hear what the other members say, but that's my point of view.
Okay, Danny, you know, I look at this and I think I would agree with you. It's a pretty eclectic situation. You have some large apartment buildings, a condo building across the street, some massive ones, which I'm familiar with. You also see those lots 64, 62, and 60. Those are little infill lots created. So I think to continue that along, or, you know, I think there is merit on what you have to say. That's my opinion. Other members?
I'm just looking at Street View right now, and there is a 3-story multiplex right beside this property. So, and it's
behind it.
Yeah. So, and it is facing a green space that you can't really build on, a small public right of way. And then there's the tall tower. So, you know, it is a unique lot for sure.
Yeah, I'd like to echo that. And, you know, normally I take issue with rear yard setbacks on new builds, but this is unique. And that rear facing is that 3-story multiplex. So I don't see an adverse effect of that.
And just one remaining comment is from me is that if we don't want to refuse 3 in a row. It'll be like the referees in last night's Leaf game. So, Mr. Taylor, what were you going to say?
Yeah, just very quick. My only concern with this is the 4-foot backyard, and I wouldn't buy one of these houses, but that's irrelevant to our considerations.
And again, there's the desire to create more housing in the city, like several of the applications we had today. So this would allow 1 further unit.
Yeah, I would look at it as 2 garden suites, and the setback would not be that much different.
Yeah, and like I said, there's a large apartment neighborhood right across the street with massive suites. With some of them have over 400 suites in them. I believe 65 M&A and B has 450 suites. So it's a eclectic neighborhood here, including the is that the hospital behind as well, 100. Okay, and Mr. Taylor, you wanted to add Pine for us? You said, oh, you already did. You said you
Yeah, you weren't listening.
Right. I heard 4-foot backyard, and I would be more concerned with the apartments across the street than the 4-foot.
I made an unprofessional remark about my preferences in housing type.
That's okay. I opened the door to unprofessional comments today, and perhaps we should be having these in the morning when we're fresh through these severances that we've had 4 in a row. Anyway, so Mr. Bellissimo, would you like to make a motion?
I can, Laura, I think you were excited about this proposal.
Mr. Chair, we do have an area resident on the line as well.
Sorry.
Is there somebody else that wanted to speak?
Yes, we have Tushita.
Oh, right. We haven't heard from the neighbor yet.
Yeah.
Okay. Tushita.
Hello, sir.
We're sorry about that. We're
That's okay.
I
just have one concern. I know it's quite late, so I'll just put it quickly. I moved into this house this April, and I'm the only one where my garage opens, you know, in the by lane at the back. So though my front side is Buttonwood Avenue, So as a new entrant in the neighborhood, I've been experiencing racist remarks from the tenants of 3 Verona Avenue, and also the fact that there are several tenants who park their vehicles in that by lane. So that makes, including the construction workers who work at the hospital. So I'm stating this that I've had to call the parking enforcement people twice to clear my garage opening so that I could take out my car. So my concern is with the construction that will go on, I know there'll be lots of trucks coming in that by lane. I fear my right of way going in and out is going to be a problem. So that's my concern, sir.
Okay, I'm just looking on the location map. I see where you are at 73.
I'm at 73 Buttonwood Avenue,
That
sir.
doesn't look like it's near. You have number 3 in between you. So this is for number 5, where they want to build 2 houses. And
I understand that, sir. But, when the trucks come in with the construction stuff, I'm sure they're going to use the by lane there because
Well,
that's the only space that is there.
you'll have to call, enforcement because, there's construction all over the city. And when we look at planning the build forum, ma'am, we don't, if you have issues with the construction, obviously someone builds something, it's a lot of disruption. That's not something we take into consideration. We're the planning department. We deal with planning concerns. So I advise is you do have redress of people either from the hospital or from the apartments or anyone else interferes with your lane. Or the people who are going to be building this, you have to contact parking enforcement, as you said you've done in the past. Okay.
Okay, so that's my only option, sir?
Right. Do you have any problems with in terms of coming to us, do you have any issues with this fact that they're splitting the lot in terms of the built forum, other than the fact that perhaps potential more impact on your lane by the construction of these 2 houses if they're approved?
Okay, yeah, that's my concern. Other than that, the splitting of the house is not my concern. I agree that.
Unfortunately, ma'am, that's what we're here to deal with. Not to belittle any of your concerns, but make sure you deal with parking enforcement. And if necessary, the building department, once they get going, they could perhaps assist as well.
Okay.
Okay, thank you, ma'am.
Thank you.
Okay, and sorry for forgetting about you. It's late.
No, that's absolutely okay, sir.
Okay.
I understand it's end of the day.
Yeah, Mr. Bellissimo's idea got us all excited because he actually changed my mind. Okay, so we now heard from the neighbor. I don't think we need a rebuttal to that. So is someone ready to make a motion? Mr. Kamarick.
I'm good to go with a motion. I just wanted to clarify something here on forestry. I know they're requesting condition 1, but I had a note here that they're also requesting condition 3. Is that correct? Just asking for staff.
Actually, they wanted to refuse it.
I know that.
To refuse it.
I know that they're asking for.
And then 3 was what I've got here.
Okay, but there's also there's a letter from them that's specific to this item that I believe is also asking for condition 1.
You're right.
That's my read as well.
So it's 1 and 3 then.
It's 1 and 3?
Yeah, that's my read.
Okay, just wanted to clarify that because I had notes in 2 different places.
Okay.
So I'd like to move approval subject to forestry conditions 1 and 3 and the usual ECS conditions associated with consent.
Thank you, Mr. Kamarick. Seconder for that motion, Mr. Taylor. Thank you. All in favor? Okay, opposed?
Oh, sorry, I'm in favor. Sorry.
Okay, so it's unanimous. You have your approval. Thank you so much, Mr. Lopez. Thank Mr. Bellissimo for as well. Okay, our next application, we do have one more severance, but it looks like this one planning is not commenting on. 77 St. Andrews Boulevard, parts 1 and 2. And this is an application. Consent to sever the property into 2 residential lots. Note, I did not say undersized, just 2 residential lots. each to be developed as the site of a new detached dwelling with an attached garage. In each case, I think we have how many variances? Any variances? Yes. Looks like we have 5 variances. We have a cover letter, a lot study, arborist report, presentation materials, being photos of approved severances, and memo from planning saying they're not commenting, and 4 letters of support. And the speaker is Leo Mastrandrea. Welcome, Mr. Mastrandrea.
Yes, good afternoon, everyone. My name is Leo Mastrandrea. I'm the agent at 77 St. Andrews. Our application is to sever the lot and construct 2 new dwellings. We did reach out to the neighbors affected, and we have submitted 4 letters of support. But in addition, we've also got verbal support from 79A, the other neighbor, 81B, 80, 76, and 73. Community planning has no concerns. Forestry has no concerns, and we agree with their conditions. Development engineering has no concerns, and we also agree with their conditions. We've submitted supporting material, including a lot study, to help justify our application. It is my submission that this proposal does meet the 4 tests of the Planning Act and is a perfect opportunity to create a new lot where it does not negatively impact the neighborhood. All the variances are minor in nature, and listen, if you have any questions, I can answer them.
Okay, thank you, Mr. Mastrandrea. We also have, I forgot to mention, urban forestry conditions 1, 2, and 3, and in the additional materials we received last night in a separate email, an engineering report, just to wrap things up. So anyone have any questions for Mr. Mastrandrea, or someone ready for a motion?
I do have just a very, very minor concern with regards to the setbacks. Well, in both part 1 and part 2, you're asking for a variance on east side. Why is one of them not on the west side? In other words,
you're absolutely right. So the thing is that if you pull up the site plan, my site plan, I can just. You're absolutely right. We should have switched it, but it was too late in the process. But if you pull up my site plan, it's only for the first 20 feet, the garage. And we did speak to both adjacent neighbors, and they don't have any concerns about it. So again, it's just for the first 20 feet, and then it steps back to the 4 feet. So we do comply at the rear of the property, and it is minor in nature, and it is also consistent with what's also been approved in the area.
you know, fair enough. I just thought you could have done better, and I guess you realized it. So.
Yes, we did. I should have flipped those and put those in the middle. You're absolutely correct. But the problem with that was the trees. So there was 3 trees, and we tried to protect 2 of them, or I was trying to do my best to accommodate everyone. But unfortunately, that was one thing. That's why we did speak to the neighbor, and they didn't have any concerns. Once they didn't, we just moved forward.
Okay, fair enough. That's the only concern I had.
Okay, so any other questions or concerns, or is someone ready for a motion?
I'm good to go with the motion unless anyone has any questions. I'd like to propose approval of the severance and the variances, having heard the explanation, subject to forestry conditions 1, 2, and 3, and subject to the ECS usual conditions associated with severance.
Okay. Thank you for that motion. Do we have a seconder for that motion? Ms. Alderson, thank you. All in favor? You have unanimous approval. Thank you. Be well, Mr.
Thank
Mestre.
you. Have a nice day.
Okay. Members and staff, we have 3 more unit applications. They're all deferrals from previous hearings. Looks like one we have Andy Scholes here. The other one we have Andy Scholes and a bunch of other people. And then one is just the agent item 30. So do you want to take a short break at this point, or do you want to forge through? We've been at it for 2.5 hours already since the afternoon started.
Maybe just 10 minutes, 5 minutes, 10 minutes.
Okay. 10 minutes and we'll return at 5 to 5.
Yep.
And
Sounds good.
Okay. Thank you. Okay. Stand on the next page. Okay. Okay, welcome back. Next application is item number 29. The rest of the applications this afternoon, the last three have all previously been deferred. In all cases, we have the minutes and the materials from the previous hearing in our packages. So next application, which was deferred from the October 13th, 2022 hearing, is 43 24th Street, a detached dwelling with an attached garage with 3 variances. We have an applicant email containing the updated plans that they confirming that they matched the revised zoning review dated September 7th, and that nothing has changed except for project descriptions now updated to be a new build rather than addition. So that's what's happened since the deferral. We have an applicant's presentation with photos and comparables, a planning email that they're aware that it's now a new build and that their previous report still stands. I believe that was a negative report. Oh no, it was a report for information dated September the 28th. Okay. Okay, so that's basically where we are. And the speaker is David Eagleman, agent, and as well we have Mr. Scholes, present on behalf of the Long Branch Neighborhood Association. Welcome back, Eagleman.
Thank you, Mr. Chair. Through you, Mr. Chair and committee members, if I may go ahead with a brief presentation.
Yes, go ahead, please.
Thank you, Mr. Chair. So through you, Mr. Chair, you and the committee members may remember this application from just over a month ago now. The only reason we deferred from the last hearing was because there was an error on the notice, which identified this as an addition where it is in fact a new build. So we did submit revised plans, but those revised plans don't change the proposal. It's just to correct the description of the proposal. And so everything is now correct.
Okay, so I misunderstood it. It was just a misdescription. You didn't make changes that now call it a, sometimes applicants come in and they say, well, we realize we can't save enough walls, so it's now a new build. This was always a new build. It was just misdescribed.
Yes, through you, Mr. Chair, that is correct.
Okay, thank you.
And through you, Mr. Chair, there was a previous deferral even before the last one from the beginning of the year. That deferral was in order to further consult with staff and to address concerns expressed by staff as well as some surrounding neighbors. So since that original deferral, we have consulted with staff. We have made quite extensive revisions to the proposal. It was previously proposed as a flat roof dwelling that has since been revised. We have made a number of revisions, have eliminated some of the variances, and it is our understanding that is to the satisfaction of planning staff. They did not express any concerns or objections with the revised proposal as indicated by their previous staff report, which they have indicated still stands. There are now only three variances that we're dealing with. And I will note that the previously submitted transportation report is no longer applicable due to the revisions that we have made, although transportation has not expressed any concerns or objections anyway. And Urban Forestry has provided an updated memorandum, and they did recommend standard condition number 1, which is acceptable if the committee decides to approve the application today. And additionally, we have consulted with surrounding neighbors regarding this application and have received support from some of the surrounding neighbors, including the adjacent neighbor at 45 24th Street. Regarding the variances, we are really dealing with only one variance here, which is FSI. The The south side yard setback variance, which is directly tied to the south side eave setback variance as well, is a currently existing condition, which is being maintained with this application. We are actually very slightly increasing the existing south side yard setback, although it's a marginal increase. So it is essentially being maintained. And that is demonstrated and shown in photo number 1 of the submitted photos that I have provided. So really, in regards to the main variance here, which is the FSI, that will be the additional massing will be spread over 2 floors and will be in keeping with the existing character. The new dwelling includes modest ceiling heights of 8.9 feet and 8 feet for the first and second floors, respectively, and the proposal is compliant with the maximum height and overall wall height. The proposal is also compliant with all required setbacks, with the exception of the south side yard setback, which is an existing condition that is being maintained. And all of these factors contribute to the fact that the massing of the dwelling is in keeping with the character and is appropriate for the lot. There have also been a number of approvals for FSI in the neighborhood. I'll just mention briefly some of them. 21 24th Street, approved at 1 times the lot area. 25 24th Street, approved at 0.94 times the lot area. 30th 24th Street, approved at 0.68 times the lot area. 84 24th Street, approved at 0.76, and 40 Elder, approved at 0.96 times the lot area. So the massing of the proposed dwelling is in keeping with the character of the neighborhood. I recall from the last committee hearing that a main concern was the fact that this will stick out in the neighborhood because of the design being a garage and integral garage with 2 stories above it. However, the submitted photos that I've provided demonstrate that design is existing in the neighborhood, specifically on the street, and the proposal will be in keeping with that. So I'm of the opinion that this proposal fits in with the character of the neighborhood. And I believe this application represents good planning and meets the 4 tests under section 45.1. So I'll be happy to answer any questions.
Okay, thank you, Mr. Eagleman. I have just one quick question for you. First of all, there were letters of opposition. There's one about traffic, the 40 from 45 next door, and somehow this was misfiled, and I asked it on an earlier application this afternoon where there wasn't a mutual drive. In fact, here you do have a mutual drive, and this lady's letter, who I read out in the other application, she just wants to make sure that, you know, construction equipment, it's not really before us, but this is a mutual drive, and this is where this letter should have been. So she's obviously just concerned with the traffic for construction through the mutual driveway. So
yes,
you can address that. I guess it's not a real planning concern.
Yes, through you, Mr. Chair, I would agree. It's not really a matter of a planning concern. However, I can say that it is a reciprocal right of way that has to be maintained as open, and it needs to provide access for both lots. So any proposed construction will have to be in compliance with the city standards, and that is all I can say.
Okay, and then when we have the planning report for information, so they're not opposed. So members, any questions for Mr. Oh, we have another name. We have the neighbor, right? Or no, we have Mr. Scholes. Mr. Scholes
has a question about the right of way, because I lived in a house with right of way. Could you address the right of way stops at the I don't know, hard to tell, but it stops just beyond the house of number 45. And then it flares out to your lot and their lot. Without the flare, I don't think they'll be able to get through. How are you going to ensure that they can get access to their garage, a neighbor's garage? I'm just, because you're not using the driveway, and you're not having a garage in the back, correct?
Danny, the right of way doesn't flare.
No, the right of way doesn't flare. That's what I said. The right of way does not flare, but with the the functionality of the right of way is to get access to the neighbor's garage. So I'm saying if in order for the neighbor to get access to their garage, I believe they have to go on your property and vice versa in the existing conditions. Is that not correct?
Through you, Mr. Chair, the right of way is on both properties, the subject property and the adjacent neighbor to the north. So it is a reciprocal right of way. So that means that both properties have a right to use that as an access. And our intention is to maintain that right of way wholly and to allow the neighbor to continue to use it as it is currently being used.
But also beyond the right of way, if you put up a fence where it says asphalt driveway on your property line, which is to the right of the right of way, they can't get access to their garage. From what I can see here in this, you have 1.2 meters there on their side. And I realize it's not a zoning issue, but as I said, for one who's lived for 50 years on a right-of-way issue like this, I just want to make sure that you don't intend to put a fence up there that block access to their garage beyond the right-of-way. I can see where the right-of-way stops and starts. So your intention is to keep keep access to that neighbor's garage, what you're saying.
Yes, I believe that is the owner's intention. I can't speak to any specific fence that may or may not be constructed. But what I can say is that I'm not legal counsel, but I understand that there are some rules around access that is being used for a certain period of time that has to be maintained.
Right. So without
Thank
getting
you.
into it, your client obviously will respect whatever.
That's fine. Michael, he answered my question about the use, the time period. Thank you.
Sorry I raised it, but I'll ask you a question, Danny, then. Aside from during the construction, which really is not an issue before us, and I know I'm the one who raised it, after the built form, would there be any impingement on the right-of-way or the neighbor entering their garage? Let's talk about the built form rather than during construction. However they marshal during construction, that's not before us. I'm sorry I raised that, but is there an issue, Danny, with the built form interfering with the right-of-way or the access to the neighbor?
If you ask me, there is, based on my experience with right-of-ways. I've had 40 years experience with right-of-ways. Yes, what happens in these situations is that beyond the right-of-way, which stops at a certain point, if this applicant puts a fence up, they actually block access to the garage, even though there's a right-of-way, because the right-of-way is not extended adequately for a car to get by. That's all I'm raising.
Okay.
And I know that
Danny's concern is that the right-of-way terminates at the end of where the new house is going to be.
Exactly. So it is really a planning issue.
And through you, Mr. Chair,
yeah.
if I might just add that also has nothing to do with the built form itself, because the dwelling is not encroaching onto the right of way, and as per the plans as of now, I don't believe there is any fence proposed along that property line. So I don't think this issue has anything to do with the actual variances that we're seeking and the proposal that is in front of the committee today.
Fair enough. Okay.
So that's what I said from the beginning. It's not. But as a person who lives in Toronto with a lot of these mutual driveways, and because you're not maintaining your existing garage, if you were maintaining your existing garage, you would have access to your garage as well. But I'm looking at the site plan, and if your client puts up a fence beyond the right of way, you block access to the neighbor's garage, and then there's a legal matter. But as you said, because of precedent of the length of use, then the neighbors have to work it out. Thank you. You've answered my question about the length of use. Thank you.
Okay. Thank you. Does anyone want to weigh in with a motion, or is there any other questions?
Mr. Chair, did I not hear that we need to hear from Mr. Scholz?
Isn't Mr. Scholz on the line?
Oh, yeah, sorry. Okay, you're right. It was just about an end, Danny. Okay, we have to hear from Mr. Scholz. Sorry, Mr. Scholz.
A little bit of a panic there.
Yeah, okay,
Andy
no.
Scholz, 12 Jasmine Avenue, a member of the Long Branch Neighborhood Association. I note there's been, as I said before in the previous hearing, I note there's been some improvements to the appearance of this new build over the original plan, including redirecting the driveway, maintaining the tree in the front yard. These are all good things. Unfortunately, the house still maintains an excessive floor space index of 0.63, an improvement from 0.68, but we're still well above the prevailing density of 0.35 in the area. If this home is approved, it will be the tallest building on the block with the highest density. The home will present as a 3-story building, due mainly because of the inclusion of the integrated garage with 2 floors above. The garage is a space that's not included in the FSI, so it will certainly affect the massing of the house. This certainly will not reinforce the physical characteristics of the modest detached homes elsewhere on the same block. Looking at the image of the streetscape from the applicant's file, this build will be taller than the triplex a few doors down. Should this plan build go ahead, it will certainly serve a precedent for the negative character change, and which will see the disappearance of plantable space for large canopy trees, animated front porches, which will be replaced by small integral garages, which in most cases are seldomly used to store the family car. The integral garage with 2 floors above is contrary to the attributes outlined in the Long Branch Neighborhood Character Guidelines, a document that was produced to instruct how a character of Toronto's neighborhood could be maintained, something that the City Council thought was in danger of being lost without strict controls on development projects. Hence, the Long Branch Character Guidelines were adopted by Council. This style of oversized house with an integral garage occurs only 5 times in the broader neighborhood, and all of these homes are located in the RD zone on 24th Street north of Elder, which is out of the immediate context of this home. These 5 homes all predate the adoption of Long Branch Neighborhood Character Guidelines. There's a specific reference last time to 25 24th Street. This is a tall home, yes, but there's only 1 floor above the garage. The objective of the character guidelines is to identify the neighborhood's key character defining qualities and ensure that future developments are undertaken in a manner which is contextually sensitive and responsive to the broader neighborhood character in keeping with policy 4.1.5 of the official plan. In order to accomplish this, the guidelines incorporate a destined methodology which evaluates future development at 3 concentric scales, including property relation to adjacent property, the property in relation to the street and block segment, and the property in relation to the broader neighborhood context. The design of this home would go a long way to maintaining the neighborhood character if the integrated garage was eliminated from the design. 2-story home was built on the site while maintaining the present parking solution. I mentioned the altered driveway will likely not necessarily necessitate the removal of the tree in the front yard. That seems to be good news, but the other trees don't get mentioned in the revised application. In fact, the applicant requests the removal of the arborist report. In the file, no mention of additional tree protection or the planting in the backyard. The LBNA would request that the committee refuse this application today. Long Branch is experiencing a threat to the stability of our neighborhood with significant increase of applications and construction of dwellings that are out of keeping with the low density character of the neighborhood. Approval of this application will quickly lead to the deterioration of the character on this street that has been experienced on other streets in the greater Long Branch neighborhood. Thank you for listening to me.
Thank you, Mr. Scholes. So planning is okay with this application?
So I have a question of Mr. Scholes, if I could.
I'm just first to ask him, is planning's okay with this? We have the report to September 28th stands. That was based on Mr. Eagleman or Mr. We have this report here, right? So, okay, go ahead, Laura.
So I understand what you're saying about this particular block. This particular block is basically bungalows and 1.5-story homes, with the exception of a couple of 2-story homes. And I understand what you're saying about this block, but once you leave this block, I'm looking at 100 and 102, 24th Street. There are soldier homes there with integral garages with 2 stories above them. You know, it just is there. There is a precedent for it on this street. Maybe not in this particular block, but on the street, there is definitely a precedent for it. So I just wanted to say that, that's all. And I don't know if you have anything to add to that, Mr. Scholes, but I just wanted to say that.
You know, I'm not a fan of soldier homes. The integrated garages go against Long Branch neighborhood character guidelines. As I say, those homes further up the street are in an RD zone. This is in a different zone south of that. I'm not sure if that applies much. I mean, there are homes in the area that really are too big, in my humble opinion. And we continue to look for stuff that is going to reflect the character of the neighborhood and, of course, preserve trees. And soldier homes usually result in a removal of at least one tree.
I do agree with you that this is will be the tallest one in the block. But
anybody else has a question as well? Maybe I'm going too far on this, but question for the presenter. The Long Branch character guidelines were adopted by council, and yet staff here is saying that this proposal does not have is integral garage and main floor of the proposal variety to address the front and side. So they have no objection to that. So there's a difference of interpretation. Do you, in your presentations, ever contact staff, and have you contacted staff regarding this? Because there's two interpretations. It's your interpretation of your Long Branch character guidelines and what staff is saying. I just wanted to know. I'm a bit confused here which way I should be going on this one.
I believe the staff has identified that the integral garage with 2 floors above is not compliant with the guidelines. That's our view. Staff reports and all reports sometimes seem to waffle, I think, back and forth. Sometimes they're helpful, sometimes they're not.
Okay, just that they're saying that the integral garage is not a problem. From what I'm reading from the earlier report that Michael was saying, there's comments still stand. They definitely say that although the application proposed an integral garage, that there are other features that meet the guidelines. So they're not opposed to integral garage from what I'm reading. Is that correct?
They have other features that meet the guidelines. Doesn't make the integral garage any more appropriate.
No, I agree, but they're saying it is. Okay, I just wanted to make sure I understood what they were saying because I wasn't clear. Thank you.
Okay, thank you, Danny. Any further questions for Mr. Scholes? So we'll go back to Mr. Eagleman for his rebuttal.
Just a comment, really on Danny's earlier question too. If we didn't have the integral garage, you wouldn't have the concerns around the right of way because they would have to maintain it to both garages.
Okay. Is there a height variance?
No.
Okay, because you said it's tallest in the street, so how can it be the
tallest in the block?
Okay, but it's within their rights under the bylaw, right? If they
No, I wasn't suggesting it wasn't.
No. Okay, so should we go back? Any other questions for Mr. Scholes? We'll go back to Mr. Eagleman. Okay, Mr. Eagleman.
Yes, thank you, Mr. Chair. So through you, Mr. Chair, I would like to concur with that point you just mentioned, that we are complying with the maximum permitted height. There is no height variance being requested. So the proposal is compliant with height. There is no, we're as of right. In regards to the garage and the 2 stories above an integral garage, the garage could be removed entirely and the proposal could be redesigned so that there is no integral garage, but the FSI could remain exactly the same as what is being proposed today, because the garage is not included in the FSI. So and there also are no variances pertaining to the garage. So the FSI cannot really be tied to the garage, the integral garage. And just in regards to the Long Branch character guidelines, yes, we are subject to the guidelines, but as per the Long Branch character guidelines checklist, it specifically notes that a variance must be requested in order for you to be subject to the certain requirements of the guidelines. And there are no variances pertaining to the garage that would need to be addressed in terms of the Long Branch neighborhood character guidelines. So that is the point I would like to make on that. And in regards to the arborist report, Mr. Trolls mentioned that it was requested that an arborist report be removed from the application, but I am not aware of that, and there is a previous arborist report on file. However, since that arborist report was submitted, the plans were revised, and there was not enough time to get an updated arborist report. However, we, based on information that we've received from the architect and the owner, there is only one bylaw protected tree, which is a city tree in the front yard, that is being maintained and fully protected. It may require an injury permit from urban forestry. However, that will have to be dealt with through urban forestry in order to receive a building permit. The intention is to fully maintain and protect that tree, and that is the only bylaw protected tree that would be affected by the proposal. So just in regards to the FSI, again, it's very much in keeping with other approvals in the neighborhood. And lastly, in regards to the right-of-way issue, again, I'll just mention that none of the variances pertain to that right-of-way issue, and that's entirely a legal issue that is not within the purview of the committee. So it is not really an issue that should be dealt with at this hearing. Thank you, Mr. Chair.
Thank you.
Anybody else has a further question now? And I think we all said that the right-of-way was not part of this purview, but sometimes we ask questions related to other issues because there's more to housing than just with variance and zoning. But I'm a bit confused. Are you saying that the 0.35, which you're allowed, and you're going to 0.63, which is almost 80 square meters more than you're allowed, that the garage is not included in the FSI calculation? Is that what you're saying? What the FSI was calculated, the garage was not included or is included?
Yes, through you, Mr. Chair, the garage is not included. So what I was trying to say is that the garage could be removed and the FSI variance would stay the same. So
I understand, but that's not my question. My question is, and I believe this is what you're saying, that the FSI does not include the garage. So if you do include the garage, the FSI would be higher. But in your case, you do not have to include the garage and the FSI is excluded, correct?
yes, that is correct. And
That's
the
what I wanted
point,
to clarify. I just want to make sure the members understand this, that the garage is on top of the FSI, but it's excluded because sometimes garages aren't. In this case, the garage is. So the garage is making the house, the overall size of the house bigger because it's a garage integrated as opposed to a garage in the back. I just wanted to make sure I understood that because sometimes we're not told that, but thanks for clarifying that.
through you, Mr. Chair. Mr. Komarek has a question.
Yeah.
I just wanted to make a comment. If the garage were removed and the FSI were kept the same, the visual impact of massing of that house would be reduced. That's my comment.
And through you, Mr. Chair, if I just may add that if the garage is removed and the FSI variance stays the same, the implication of that statement is that the garage has nothing to do with the FSI variance. And the garage is permitted as of right because there are no variances related to it.
I'm not making a legal argument. I'm making a planning argument as to visual impact.
And through you, Mr. Chair, I'll just lastly note that, in my opinion, this is a very straightforward application. It's really only one variance for FSI. So thank you.
Okay. Any further follow-up questions, or is somebody ready to let's bring it into committee for a decision? Any discussion or motions? It's time to move on this one. Mr. Taylor.
I'll make a motion. It was a correct comment that this is going to be the tallest house on the block. However, there is no height variance required. There's been much discussion about the massing of the house. I think we can all agree that the zoning bylaw requirements would limit the house size to 105.6 square meters, which is 1,130 square feet, which is not desirable or marketable nowadays. What is proposed is a 2,037 square foot house, which I think is quite within sort of reasonableness. I'm going to move approval subject to urban forestry condition 1.
Thank you, Mr. Taylor. The second for Mr. Taylor's motion. No seconder. If that motion fails, do I have another motion?
Danny, but this one I'd like to make a motion. I find that the variance number 1 is in excess of what zoning is allowing. And also I find that the lack of the integrated garage is not in the characteristics of the Long Branch design guidelines, which were approved by City Council. And so I agree with the opponents. And so I would like to move that this application be refused.
Thank you. Do I have a seconder for that motion? Ms. Alderson? Thank you. All in favor? Opposed? I'm opposed. Motion carries 3-2. The application is refused. Okay, thank you, Mr. Eagleman. Thank you, Mr. Scholes. Okay, our next application is 26 Vimy Avenue. It was deferred from the July 28, 2022 hearing. It's to build a detached dwelling with an attached garage with 3 variances. This matter appears to have been deferred. They wanted to drop. They dropped the variance and they asked for the adjournment to consult with city planning. So you read the planning report, and this is my pet peeve. They feel it's too much GFA, but for some unknown reason, Assistant Planner Diebler says we should just refuse variance number 1, which is the major variance, the FSI at 0.78. It's a big secret as to what he would find agreeable. He said that without the attic space being used, it would be 0.65. Didn't mention that. And he just didn't mention, so he just wants us to refuse that 1 variance, which obviously, to Mr. Diebler, to someone and those reviewing his report back in July, which apparently still stands, if in that case, you have to refuse the entire application because the other very few minor variances do not stand on their own. So without an FSI, you're not building anything here. So that's what we have before us. The agent is Y Mao.
Yes.
For the applicant. Good morning, good afternoon, good evening, sir.
Yeah, good evening, everyone.
Yeah.
Yeah,
So you deferred, you didn't make any changes after you spoke to community planning. They don't seem to, they keep a secret as to what they feel they would accept. They don't mention it in the report or suggest we approve it at a lower number. They just said refuse variance number 1. So I don't think we can refuse variance number 1. We refuse the whole thing. So can you please make a presentation to committee as to why, notwithstanding the community planning report back in the summer, this application should be approved at 0.78.
Yeah, so after the July, so we revised the plan and we reduced the space floor from the 2nd floor. So the FSI is from the 0.78 reduced to 0.55.
Do we have that, staff? Do I see that? I thought we're still at 0.78.
No. So we got the new rolling notice from the city on the it's
this application appears to still be at the same 0.78 it was at in the summertime.
No. we already revised our plan, the FSI from 0.78 reduced to 0.55.
Oh,
Notice says 0.55.
oh, it
Yeah.
does. Okay, what was I was looking at the notice in the.
We're looking at the old one.
Okay, sorry. So you're at 0.55.
Yep.
Oh, and community planning was opposed at 0.78. Okay. So you've given me the magic number. So is community planning, have you spoken to community planning? Because they haven't issued an email saying that given the revision, that they're now satisfied at 0.55. Staff, do we have anything about that? And my apologies. I thought it was.
That's fine. That's fine. Yep.
And their email says you stated, oh, that was back in July. They didn't give us an updated report.
No, we don't have anything new from them.
And didn't they say that their report stands?
That may have been for an old application.
Okay, anyway, they brought it down, not at 7.8, not at 6.5, which is with the attic space at 0.55.
Yes.
So the committee has to decide whether that is reasonable. So let's see if anyone has any questions for you or if we're ready for a motion. I'm sorry for confusing that.
That's fine. That's fine.
Okay.
Danny Bellissimo's ready for a motion if there's no further questions or any questions from members.
Yes, sir.
This is a corner lot and there's a park beside it. And so I find that the variances are minor in nature and have very minimal impact on the neighbors. I don't see any opposition here. So I'd like to move for approval. I know that I think forestry is saying no to it, but I don't understand that. There's been no, I can't see that. And the planning information is completely confusing for me. So I'm just going on the merits of what I see in the application, the drawings, and the location of the site. So I move for approval of the variances with no conditions.
Okay, thank you, Mr. Bellissimo. Mr. Comeric?
Yeah, I'd like to do a friendly amendment and add forestry conditions 1 and 2. I believe forestry is saying if we don't refuse to put in the conditions to protect.
Reasonable, Danny? Accepted?
Yeah, so that's not in the summary sheet. It's in the attachment, correct?
I don't recall where I made the note from, but I took it from somewhere. So.
Okay, because I don't see it in their summary. The summary is just
It's in the standalone report in the file where they list their objection.
Report. Okay.
Yes.
I'm looking at it now. Deny 1, 2. Okay. So I would agree to that amendment. Thank you.
Okay, thank you, Stan. All in favor? I can't see visuals. Who's okay? It's unanimous. Thank you. Okay, and apologies, Mr. Mal, for thinking you were still at 0.78.
That's fine. That's fine.
Okay.
It's a too long time. I know. Everybody is tired.
Yeah, I shouldn't do my reviews during the hockey game. Anyway, item number 31, our last application of the afternoon, 3753 to 3755 Lakeshore Boulevard. This is to permit a parking deficiency to accommodate an additional 12 residential units within the existing 2-story mixed-use building. The existing 3 residential units and 1 commercial unit will be maintained for a total of 15 residential units and 1 commercial unit proposed. And the 1 vacancy is the parking. A total of 18 parking on-site spots are required, 15 for resident, 3 for parking. And here, no on-site parking will be provided. We have applicants' revisions, cover letter. This matter was deferred back in September 1st, 2022. Cover letter, we have a parking study. I think it was probably deferred for the parking study. Planning has a recommendation, condition of approval to be constructed as illustrated in the floor plans regarding the location configuration of indoor garbage room, gym, games room, bicycle storage, increased window sizes, and revised unit layout for apartment number 9. And then we have Metrolinx advisory and the materials from the previous hearing. The speaker for this is David McKay. And we have several speakers, several neighbors, a resident to speak, including the Andy Joels on behalf of Long Branch. So,
Mr. Chair, Danny Bellissimo, did you note that transportation has in the added material a condition as well? Did you note that? There's a condition in the by transportation in the email that the owner shall advise all prospective tenants of the residential dwelling units that no on-site parking will be available for tenant use. That was in the additional material.
Thank you. That was in the additional material as well as I believe. Yeah, so we have, that's
Okay,
right.
just wanted you
The
to-
email dated November 22nd. So it's just an advice notice that they have to put that on their advise all tenants, which
Just want to make sure that was
yeah,
noted.
seems very reasonable. So yes, thank you. So let's hear from Mr. Mackay, who I'm sure is aware of that.
Yes, thank you, Mr. Chair. Yes, I'm aware of the conditions and the comments. With this is an interesting one in that it's a adaptive reuse of an existing building. It was a place of assembly, which has become vacant. Our client originally had proposed at the September 1st meeting to put office spaces in the unit as well as the 3 residential. That was the raised concerns with transportation staff, and so that's why the deferral occurred. We then, looking at the market and how things are going in terms of housing, he revised the application to change it to the residential proposal only, provided the additional materials, and you can see that transportation is satisfied with the request, subject to that condition. This is an interesting one in that it is an existing building that is basically lot line to lot line in all 4 directions. There is no ability to provide on-site parking without demolishing the building, which in our view is not an appropriate remedy. If we're going to demolish it, we might as well rebuild it as a substantially new building, greater density, everything else. And my client doesn't want to proceed that way. He wants to keep the existing building and retrofit it. Relative to the merits, yes, there is no parking provided. We are providing for substantial bicycle parking room within the building. As per the transportation report, there are 52 parking spaces along Lakeshore Boulevard West within a 2-minute walk of the site. There is ample transit provision in the area, including the streetcar line and several bus routes. I know the comments from the neighbors are relative to parking on the side streets. However, those are public right-of-ways where parking is permitted. So I can't do anything about that. If there's enforcement issues, that is an enforcement issue with the city parking division. However, our client believes this is an appropriate use of the reuse of the building. I do note that council, as I mentioned at the first item today, I've been here all day, that parking is not required for resident uses as per council's recent direction and approval at the Ontario Land Tribunal for the overall city. And unfortunately, this is an anomaly in that it's the old bylaw, not the new bylaw. But we are providing, there is sufficient visitor parking in the area to accommodate that visitor parking. So with that, I'd be happy to answer any questions that committee or the neighbors may have. Thank you.
Okay, thank you, Mr. May. Any questions for Mr. Mackay, or we'll hear from the neighbors, start hearing from the neighbors?
Just a quick question before we go to the neighbors, if we may. How many on-site bike parking spaces are being provided?
Just let me. Sorry, I'm just trying to find the statistics there. The room that we have is approximately 19 square meters in size, and I have I have 16 vertical parking spots shown at a minimum within that space, and there's more than sufficient to provide horizontal space as well.
Okay, and these are interior.
This is interior. It's in the basement, which has direct access to the outside via stairwell.
Thanks. My second question then is the parking that you referred to on Lakeshore Boulevard, is that time limited?
Yes, there are time limits between certain hours of the day.
There are no parking restrictions during certain hours.
That's correct. That's my understanding.
And I guess I just want to point out, we do have before us, I guess, since the adjournment, October 6th, you have a parking justification or a no parking justification study as part of your materials.
Yes, we had one before, but staff were concerned with the office component. And so that, as I said, my clients revised the proposal accordingly. and they've now signed off on it.
Okay.
Anybody listening had a question as well, just for clarification, looking at your floor plans and your elevations, and it seems to me that this building probably has a long history. It looks like there were two buildings that were in two stages. Is that correct? Because from what I understand, the visuals from the outside will not change based on what the existing condition is. Is that correct?
That's correct. There's just some additional windows being provided for.
Right.
I don't know the history, sir, but based on the floor plans, it does look like there are fairly substantive interior walls between two parcels or two parts of the building.
The clue is the second floor. Is the second floor just a quarter of the building? So they're not.
Yeah, and it's only on that one portion. Yes.
Yeah, that's right. So this seems like there were two buildings, but basically the character of that corner will remain basically the same as is now.
That's generally correct. Yes.
Thank you.
Okay. Sorry, Mr. Rogers, just one more question before we hear from the neighbors. So I note here in the previous, back in August 19, 2022 transportation report, they wanted a deferral for a parking study. So you've had the parking study. Have we heard anything back from transportation that they're okay based on that study, or?
That's the additional email that Mr. Bellissimo mentioned to you, Mr. Chair.
Okay.
Well, with the additional condition, which we're satisfied with.
Okay, fine. Okay, so let's move over now to Mr. Aaron Davis is the first speaker. He resides at 8539th Street.
Mr. Chair, Aaron Davis is not on the line, and neither is Esther Gomes.
Okay, good to know. So in that case, we'll hear accommodate Andy and hear him last. We'll hear from Mark McKeon from 5339th Street.
Sure. Good afternoon. You can hear me?
Yes, sir.
Oh, thank you very much. Good afternoon. My name is Mark McHugh, and I live at 53 on 39th Street, which is approximately 6 doors down on the same line as the applicant's parcel of land. We have some serious concerns. We've been on the street. I've moved here in 2001. Back in 2001, you could shoot a cannon down our street and not hit a parked car. Now we fast forward to 2022, and on any given day, parking can be a battle on our street if somebody's looking for it. We do get Lakeshore traffic down here. The other thing that I'd like the committee to be aware of, in just between James and Lakeshore, in the last 10 years, we've had 3 houses that were single-family dwellings that are now tenancies, but having 2 occupants in these single-family homes, which has doubled the amount of cars for those 3. Somebody else in the committee this afternoon on a different application also pointed out the issue with shared driveways, when we tend to have people putting one car on the street because they're trying not to interrupt their neighbor. Same situation applies here. There are several shared driveways on the street. We've also in the last few years had 1 lot severance, which now creates 2 more cars. And the lot directly next to me at number 51 was sold last year. It's a 50-foot lot. It now sits vacant with a developer eyeing what he wants to do with that. I do think the presenter's comment about 52 parking spots on the Lakeshore is a little disingenuous, because to the west we have several eateries, including Woody's, the Burrito Boys, and most of the parking to the west is usually spoken for most of the day and evening. So to suggest that those are going to be available, I don't think is necessarily true. So I have great concerns that this 15 potentially tenancy vehicles, they're going to come onto our street. And I think one of the reasons we like Etobicoke and want to live here is because we're not suffering from this downtown creation where every street is wall-to-wall vehicles. Our street is rejuvenated in the sense that we have a lot of small children again on the street, which is wonderful. And my other concern is that when we see the street full, it's also going to start to encourage, when people are visiting, it's pro parking. And I know Mr. Mackay said, well, that's an enforcement issue. But in this situation, the applicant is basically looking to create a large property and say, well, the amenities, that's the problem for the community, and that's the problem for the police. And I think that's not necessarily fair. You know, we live in Etobicoke, is slightly quieter. We don't look for the downtown craziness here. And I want to be very, very clear. I have not an issue with density. I agree with density more than I agree with urban sprawl. But with density and with his application comes a responsibility for infrastructure and amenities. I think if you really want to beat 15 units, and I know he'll probably say I disagree with you, but then maybe the building should be torn down and something that could be built that satisfies both housing but a place to put vehicles. I think there is a reality in our city that cars are a part of our city. And therefore, you know, they're not going to go away. So they have to go somewhere. And I really, and I think I speak with the neighbors to say, I don't see these going to sides or going to Lakeshore Boulevard. They're going to pour onto the side street. We already have challenges since COVID with Marie Curtis, which is so wonderful to see how many people come out to Marie Curtis Park, which is 3 streets to the west. But we get the parking issues because we literally have dozens, hundreds of cars, and you can ask parking enforcement, they will come down here. I'm not sure where I am on the clock. The clock is not running, sir. So anyways, it needs to, you know, I speak that I really think this is a poor planning idea.
Yeah. The clock, I guess the top clock is tired also.
So
Okay.
anyways, thank you for your time.
Yeah, thank you, sir. So, you know, and I when I was on the committee in the early 2000s downtown, and, you know, they built some big condo. It's crazy because now the condo parking requirement is not the same, and it's very expensive to go down many levels. But the agents would always come and they'd say, oh, look, you got this public parking lot and that public parking lot, knowing in the next 5-10 years, all those parking lots, surface lots disappeared for more condo projects. So again, these reports mention all these other spots that are available when, again, you know, maybe they're just people keep their cars there and there's not turnover. But that's what it is. We do have a professional, which Mr. McKay rely on, a professional parking study, which is what, you know, why this matter was deferred. And I guess he relies on that. And that's life in the big city, I guess. You're right. There's not enough parking and there's not enough place to put cars. But on the other hand, you say, well, there used to be one resident, there's now 2. So on the other hand, the city wants to encourage, you know, affordable housing by people having, you know, and the presumption is you're going to have more cars. So that's the, that question is a bigger question than we can handle here today. We're dealing with one, and I get it, every project, you know, one goes on the other, they're cumulative, but when you deal with them one at a time. Okay, thank you, Mr. McEwen.
Thank you for your time.
Okay, do any of the members have any questions or comments for Mr. McEwen before we go to last speaker, John McDonald, also an area resident on 39th Street? Okay, so let's hear from Mr. McDonald.
Hello, can you hear me okay?
Perfect.
Okay, so yeah, my name's John McDonald. I want to thank the committee for giving me the opportunity to speak. I really appreciate that. I live at 67 39th Street, which is 7 houses down from the site.
Yeah.
And I'm on the same side of the street as the site. And although I recognize the need for rejuvenation and increased housing, and I'm in favor of actually that lot going through that, I object to the last minute addition of 12 additional residents to this location, to the 3. I only found out about this change from an email from actually Mark, who was just on the line here this past Sunday night. And it was from a sign placed on the front of the existing building. This week, you know, residents, once we became aware, started to issue letters of objection, and this includes myself. There's, to my count, on the street bounded between Lakeshore and James Street, approximately 25 parking spots. Of this, 4 spots are on the east side adjacent to the building. The rest are on the west side opposite, with parking only allowed on that street from Lakeshore down to James Street. This will not be enough for the addition of 50 new residences with a new office and accommodate all the existing houses on the street. We know this from experience. So when the site was an active social club, the guest vehicles would overflow down our street, making the traffic congestion unbearable. And if you scroll through the pictures here, I've provided examples of that congestion, and there's really been essentially no changes in the parking for these photos here, but it gives an idea of this shot here is looking from Lakeshore down, and then this photo here. These two photos are actually from 2013. So I just wanted to highlight that the parking congestion on 39th Street has been ongoing for quite a while, and you can see that it's quite tight here. Just keep scrolling to the next one. Again, this is actually right across from the site. This parking right here across has been changed, so it's gone from angled parking to parallel parking, so there's actually less spots there than there used to be, and you can actually see in this photo that I took that there's a car blocking a driveway. Just keep scrolling. This is the still within our block, so this is between Lakeshore and James Street, and this is a huge issue that I want to highlight, that our street is not a planned street. A lot of the houses and lots predate the current bylaws. Long Branch predates Etobicoke even, and from about the middle of the street, I'm going to say from about 39th Street down to James Street, the parking absolutely deteriorates. And you can see here in these two photos that there's a lot of front pad parking with little to no curb parking in front. And I would say that in the case of at least a couple of the curbs between houses in this section of the street, you would struggle to get a medium car parked in front. So from about the middle of the street down to James Street here's another shot. Again, you can see lots of front yard parking with little curb availability. You can keep going. Get another shot. This is again our section of the street. You can see that in this case that it would be very tough to park cars along the curb there. This, was just kind of showing in 2019 when events occurred at the social club, that will result in parking all the way down the street. So in the case of this proposal, this strain on parking in some ways will be more sustained and more permanent, because it'll cars will be left overnight and through the weekends. Sorry, I guess we lost the presentation.
Yeah, I think you're over time, sir. If you can please.
Okay. Can I just say that winter parking makes things way worse. With the snow piled up, we lose even more spots, and the cars are forced into the traffic lanes on that section of the street, and really exacerbates the problem. And then my final point is just what accommodation would there be for special accommodation requirements for parking if no parking's provided. I want to thank you very much for your time tonight.
Okay, and Mr. McDonald, I want to thank you. You're the last speaker on our list, other than Mr. Scholes, the cleanup hitter, for staying on the line. And I just have a comment. Like, I agree, pad parking, you lose an equivalent because of the curb cut. You lose a street spot, and there's nowhere to park, and additionally, then there's nowhere to put the snow because you're using more of the front lawn. You're trying to pad, And it's and it's all over the city. It's not just Long Branch. Perhaps it's worse than Long Branch. And you're off of Lakeshore, so it is an issue. And this is one project with providing 15 units. And the question is, will people live there who don't have cars? They'll have to be, as Mr. Transportation comment is a requirement that they have to advise all tenants that no on-site parking will be available for tenant use. And as well, just a clarification for staff, if I noticed when I was reading the 3 letters of objection that came with the additional materials, the second letter just said resident of 39th, and that was Mr. McEwen's letter. So now that we know his address, just wanted to clarify that letter is matched up with him. Okay, so Mr. Choles, last speaker.
Just get a quick question first. Sorry.
Go ahead, Stan.
I'm assuming there's no overnight permit parking in this part of Etobicoke. Sorry, just for the resident, I thought he might know.
Question, Mr. McDonald, that's a question for you if you happen to know.
There's no overnight parking allowed from what I understand.
Okay, thank you.
And if that's wrong, we'll hear from Mr. McKay. Okay, so Andy Scholes, Long Branch representative.
Good evening. My name is Andy Choles, live at 12 Jasmine Avenue, Long Branch, member of the Long Branch Neighborhood Association. LBNA has been somewhat frustrated at the underdevelopment of this site, where a much taller building is permitted and with parking would be required. We have long endorsed focusing the intensification of the Long Branch along Lakeshore Boulevard by supporting the building of 6-floor low-rise apartments. That would be an apartment building with on-site parking solution. This development is on the smaller scale, but we can't support the reckless approach of no parking requirements. It simply is unrealistic to expect no one in these 15 apartments to drive a car. There will be cars, and they will be crowded mostly onto 39th Street or some other surrounding roadways. That will create parking problems now and worse problems in the future when 39th is developed to its proposed potential. You can't simply imagine your problem doesn't exist and dump it onto someone else. That is what this application is trying to do. We have concerns as a neighborhood association, but we're responding to the concerns of the impacted neighbors. The application was originally a building for a number of offices with no parking provided. The neighbors weren't happy about that and were ready to fight for that at a previous committee of adjustment that was deferred until today. Rather abruptly, that planned build has become 15 apartments with no parking. The applicant has no idea what the parking requirements of the new tenants will be. The neighbors have tolerated overflow illegal parking from the lodge for many years. There have been no studies, therefore no assurances that this will not continue at an increased level. I'm very pleased the neighbors could speak today to give you a first-hand report of the parking situation. The pictures clearly brought that argument home. It's clear 39th Street has very limited parking, not enough to fill the needs of the residents. On-street parking from apartments would be an ongoing problem day in and day out, not just temporarily through part of the day. There is no Green Pea parking lot in Long Branch to accommodate these vehicles. The application itself states no commitment to making any units affordable. As such, there's no evidence that the tenants will not need at least some parking. The available transit is a regional rail and only directed transit to the downtown. It is not the TTC subway leaving every 10 minutes for downtown Toronto. There are no policies in the official plan that encourage not including any parking for low-rise apartment on an avenue. Underground parking is not discouraged. It would be wonderful if one day we can become less dependent on the car in Long Branch, but that day is not today. The transit infrastructure is simply not there at present. Fairly recent development in the Minto stacked townhouses on the former Brown lines on the north side of Lakeshore and Long Branch Boulevard is a development that included some parking, but not enough for the people buying those homes. Within 2 years, in order to alleviate safety concerns, parking in front of fire hydrants, etc., a request was put forth to the councillor to permit street parking. Clearly, the idea that the residents wouldn't require much parking was a misguided notion. In the case of Minto development, the residents were voting to park on the street in front of their own house where there was room. This wouldn't be the case with the Moose Lodge site. The condo owners across the street from the Long Branch Go have parking contained on the site, and it's still fully utilized. The condo is probably as close as you can get to transit, and it's still the need for parking exists. The condo takes responsibility and provides parking for the residents. The only recent change to the parking arrangements was the repurposing of 2 spots for EV recharging stations. The need for parking exists on Lakeshore. I would urge the committee today to reject this proposal. Development along Lakeshore is needed, but any accommodation must provide parking for its residents. Perhaps the number of parking spaces might be reduced, but not to include any parking is irresponsible and will only create hardship in the neighborhood. I would ask the committee to read the residents' letters of objection, the traffic department's report, and the parking study, which I have to agree is a little confusing on whether they agree with this or not. And all of them seem to reject the notion that parking can be completely eliminated from this building. I would ask that the committee refuse this application today. Thank you.
Thank you. So I guess transportation seems, as long as they provide that notation, they seem to be okay with it. Is there any cash in lieu in these circumstances? Or, you know, it's just, like you said, there's no green pea lots. So if they're collecting money from these people to buy and provide green pea lots in the vicinity, that's what they do in other areas of the city, I guess. So I'm just wondering, there is no cash in lieu here. Probably from Mr. McKay. He'll know. We can. Okay, any questions for Mr. Scholes before we go back to Mr. McKay? Okay, back to you, sir. And if you can mention whether there's any, cash in lieu provision here or not.
Yes, thank you, Mr. Chair. With all due respect to the residents, the pictures that have all been shown reflect the parking situation when the lodge was operating. If you see all those pictures, you see all the commentary about overnight parking and things like that, and overflow. It's all related to a different situation, and I appreciate what they're saying about parking, but however, and I repeat this, council has made a decision that parking is bad. They don't want it, and they've removed it from the brand new bylaw. The only reason I'm here for this variance is because this is exempt from the new bylaw because it's an avenue. That will be updated and we will have 0 resident parking required. The visitor spots there is green pea parking, permit parking, or not permit, but paid parking along the street on both sides of Lakeshore. As noted, that is restricted to certain times of the day, not overnight. You can park overnight there free of charge. There is no restrictions that I am aware of in terms of overnight parking on the side streets. So that is a misnomer as well. With all due respect, we are trying to reuse and efficiently utilize an existing building that is there. It's vacant. It needs to be reutilized in some manner. This will enliven this area. It's appropriate. It's responsible. It's good planning. Relative to cash and lieu, sir, there is a provision, and I don't know if the city still uses it. I know previously I did get, one of my clients did get hit up for cash and lieu parking. That was about 10 years ago. There is a provisions. I don't know if that bylaw and that procedure still exists and is utilized, but it has in the past. So, and then there's formulas that go along with that type of payment. So I'll leave it in the committee's hands. And I'm happy to answer any further questions. Thank you.
Okay, thank you, Mr. Perry. Any questions for Ms. McKay, or is someone ready to weigh in with a motion?
Danny Belesmo has a question of staff. And I understand the transportation services report. Seems like, because I was a city staffer, so I think I'm reading between the lines. I want staff to clarify this for me. This bylaw that is 89-2022, there's no minimum resident parking requirements, but it is currently under appeal. So when a bylaw is under appeal, is it enforced or not enforced?
To clarify, Mr. Bellismo, that was approved in October by the Ontario Land Tribunal.
That's why I wanted to clarify, because the transportation services is saying that it's currently under
They're probably
appeal.
not aware of it, sir.
Sorry.
I only found out about it last week. So.
Sorry, I'm asking staff a question.
Yes, sorry, sir.
The bylaw is currently under appeal and not yet in effect. So I'm trying to clarify That's question number one. And question number two, the recommendation from Transportation Services, I'm wondering if this is going to be a standard that when this situation occurs, that all residents are informed that that the tenant will not have any parking. Have you seen this before, Barb? Is this the way Transportation Services sort of gets around it at this point, or will that be a standard recommendation?
So in the event that parking is not available in this type of circumstance, Transportation Services would make that recommendation because they don't want to get complaints that why was the building built and there's no parking for tenants, similar to storage, that kind of information. The tricky issue with a bylaw under appeal is that technically those standards are not enforced, but they could be enforced at any given time.
Yes.
So if a decision is made and then a month later they apply for a permit and then that bylaw becomes enforced, they could have to go back to committee depending on how they comply or don't comply with that bylaw. So that's why in the past, when you saw multiple variances to old, say the old City of Etobicoke bylaw, and you also saw variances to 569/2013 because the 2013 bylaw was under appeal.
So that's why they had to list the old thing. I think, you know, let's deal with this application, what's done in the future, standard wording. We've seen it before. This is what they're recommending here, which means they're otherwise fine. We also have a condition of approval from community planning, which you can imply that they're otherwise okay, other than that, their condition. So let's not, I don't think we have to look at what the standard is going to be. We have a report before us and we have this issue. So the issue is whether we approve this application or we don't, without knowing what's going to happen in the future.
I just would like to make a parking comment. In the event that there was no permit parking, and I believe that's the case for South Etobicoke, the provisions of the general Toronto parking bylaw prevail, which basically states that you can park on the street for a maximum of 3 hours. It's rarely enforced, but it can be. I just want members to be aware of that this area would be subject to that. So if someone chooses to park overnight, they potentially could be tagged anyway.
Thank you, Mr. Kamerick. Anyone ready for a motion?
I just want to comment that I agree with Mr. Choles, and it's unfortunate that this property isn't being developed as a proper mid-rise mixed-use development, and then there would be no issue. I mean, there'd be provision for parking. I think it would be a great thing for the community. I just wanted to say
Yeah,
that.
I know.
Yeah. Anyway.
No, we had Councillor Munziata at Keele and St. Clair. You know, they came for self-storage and she wanted something nicer and grander, but, you know, they weren't ready to expropriate. The applicant was within his rights, so they lost at the OLT, and the project went ahead. They just got delayed. So we can't, you know, I agree.
I know. I just wanted to comment.
Maybe
That's all. I'm frustrated.
Yeah, it's too bad.
Maybe Lismo would like to intervene and try a motion. It's getting really late here, and you know we just can't pontificate and go on all night. So I'd like to make a motion based on this. I find that the intensity of the units, 15 units plus 1 commercial unit, and the degree of impact to the neighborhood is not minor. And I find I'm not really clear that transportation is okay with this. They're putting conditions on here, and they're also saying that it's not yet in effect, the bylaw, that is. And I think that this minimum bylaw of parking bylaw has to be fleshed out better by council. I think it's dumping their responsibility onto the Committee of Adjustment. And so I find that the intensity of the proposal is just too great, and the impact is too great. Had there been fewer units, I probably would have supported, but I would like to move refusal.
Thank you, Mr. Bellissimo. Do we have a seconder for Mr. Bellissimo's motion?
I would like to second that motion too as well.
Thank you. All in favor? I lost Stan's visual. Stan, you're in favor? Okay. Opposed? Motion carries. The application is refused on a 3-2 split. Thank you, Mr. McKay. Thank you, Mr. Schultz, and the other neighbors for weighing in this application. And now I need a motion to adjourn.
Oh, yeah, I'm the first one to make that motion.
Okay, thank you, Ms. Alderson, seconded by Mr. Taylor. How's that? Okay.
Good night, everyone. Thank you, staff.
Good night,
Okay.
members. Thank you.
Thank you.
Good night.
Be well, everyone. See you next time.